Is Mr. Rakesh Kumar there? I see wrongly mentioned. Who is your other side?
Was Mr. Khan, but he did not file in Calcutta. Just already came in with submission that I'm filling for license.
Then you are required to serve at least. Otherwise, the other side will not get to know what is there. And what was the issue in this first appeal?
That the senior division passes an order. Usually, we prepare an appeal before the district judge. Then one of the party in the party came to this honorable court informing the court that first appeal has to be prepared before the honorable high court in terms of pecuniary jurisdiction. Then again the Andaman Nicobar administration had prepared one appeal wherein it was decided that district judge has the jurisdiction. So the matter went for the special the larger bench. Then larger bench subsequently decided that every appeal should be decided by the first appeal will be decided by district judge.
Irrespective of the pecuniary jurisdiction.
Paragraph last.
Page?
17. Page 17.
Page 17.
Paragraph 30. DJ has unlimited jurisdiction, both pecuniary and territorial, to hear all appeal irrespective of valuation from judgments, decrees, and final orders passed by.
That's not appropriate for
Yeah.
in view of the special
Special
bench.
bench. Very well, please come.
Coordinate myself partner.
All right, let us see.
Certified copies of the
And the same order can be passed.
Same order.
Ah. Please come. The same order will go down with only one. You have to mention the case number over here, F84, and the judgment dated 9th March 2026. It is the district court. All right. Dispose the same lines. Please take back these judgments. You will require it in other matters.
তখন দরকার হবে
আবার নিয়ে আসবো। ঠিক।
That's making the list of things.
Yes, please give. You are also preparing another list of dates. Same. All right, you give a copy, we can record CAV. All right, the list of events prepared by the petitioners and the short notes on behalf of the respondent filed in court today be written with the records. Stop hearing concluded CAV. Yes. All right. All right. Addicted to drugs. But how long is she there in the child welfare home? When did the incident take place? How long is the child there? Well, let her place. All right. Off this year. And since then she is there and we are in end of August, she is still on drugs? She is recovering. She is under medication. Where are the documents? Is she admitted to any hospital or medical institution or anything of that sort?
For the district number 3, Lordship, Police Authority Assistant Person, where the case was registered.
Yes.
I have been informed by the investigation agency that condition of the girl victim at the time of, because the allegation against 10 active person have been arrested in this time. What happened? Some drugs addicted, she was drug addict. So
Let me be obliged.
Please provide at least soft copies.
Yes.
Plus, plus, plus. My lord, I am for the afternoon, my lord.
Yes,
I think you have to.
with senior.
My lord, I pray this matter will be taken up on Tuesday because I intend to file a paper book. There was a direction. I will file it and serve an advance copy by Monday. If it is taken very short.
We can see a recording of the order that the terms of settlement.
My lord, the settlement was going on. That's why the matter was out of list, my lord.
Yes.
Now they are not agreeable. Last date, my learned friend has submitted. They are
They means,
my
Respondent.
brothers, my lord. My brothers.
what is the matter about?
Matter with regard to property, my
with
lord.
regard to the violation of.
Property, they have made a complaint.
Can it go to the Lok Adalat? Will you take a try?
But mediation, it, my lord.
Mediation.
Because Lok Adalat, my lord.
All right.
Let mediation proceedings start.
Yes, my lord.
Mediation.
There is no order. No order is there. My lord, it can be.
It can be
It
sent.
can
to
be, my lord.
mediation.
Because we are agreeable to many things, but they are adamant now.
Passover.
No, question is you try to settle before mediator. If it fails, the regular court
Because
will take
a
it up.
trained mediator can pay.
Yes, yeah, trained mediator.
Can be, my lord. I think it will be.
All right, we pass it over. Let your senior join in VC.
Yes.
We'll see. Is there a list of trained mediators?
Yes, yes, yes.
Retired High Court Judge, my ten mediators. Retired High Court Judge. District Judge to the power. High Court Judge के वहाँ काम करने में आवाज़ और कौन-सी हालत है?
অনেক হচ্ছে। Yes, call the next matter. Pass over for the time being.
I am for the petitioner.
I am for some of the private person. It's a ready matter, my lord.
Lord, I am for the rest.
এই কিছু ম্যাচ ম্যাথে সার্ভে বা
রাখো, এখানে রেখেছেন আমি তুলে নিচ্ছি।
I am submitting the list of dates.
Please give.
Tell him. Amlaya.
What is the primary issue?
The primary issue is whether the ad hoc service rendered by an incumbent can be counted for the purpose of seniority or not.
Seniority, all right.
Seniority list is under challenge.
All right, all right.
Okay.
What was the order of the tribunal?
Tribunal's order is at page number 548, volume 4.
volume 4.
দেখুন তো ভলিউম 4টা কোথায় আছে? ওখানে তো নেই। ওইটা তো দেখে যাবে। হ্যাঁ, কোন নেই।
The operative party starts from 558.
What এটা আমার ভলিউম 4 স্যার ওখানে আরেকটা আছে কি ভলিউম 4 গেল
Right up to here.
Is the opposition.
My lord,
Which is
all
the-
the relevant documents
Ah.
are annexed with my affidavit in opposition. I will ask you the
Alright.
court by giving the number. my lord.
All right, that can be done.
Otherwise, my lord, because my affidavit it's a thin one, my lord, it's not, yes,
It
I
is,
can give that.
Thin
number.
one or a thick one? 6, 7, 8, 9
Compared to
opposition.
my learned friend's writ petition, my lord,
it contains the entire proceedings.
I understand,
all
but
the
then,
proceedings are there.
there.
I can assess this.
all right, please do.
Yes.
Here, the order of the tribunal.
That is at page 194. I am just,
Page 190?
just a minute, that is at page,
59,
no, my lord, page 169, 169.
160.
Man.
All right. আপনি দেখুন ভলিউম 4টা ওখানে কোথাও হবে। Yes. Yes, please, please.
Your lordship, this entire case starts in the year 2010, when a DPC was conducted by the official respondents for filling up of the post of sub-inspector executive on promotion in the promotion category from the post of assistant sub-inspector. So now in that DPC, none of the candidates were found suitable because nobody was having the requisite experience of 6 years of service in the feeder grade. Feeder grade, none found. So therefore, the post was not filled up. And subsequently, a note was moved before the competent authority for relaxation to give them promotion on ad hoc basis, and their service would be regularized on attaining the 6 years eligibility condition. So this entire process was done based on a draft recruitment rule. Subsequently, the recruitment rules were notified, and the percentage fixed in the recruitment rule was 50-50 earlier. And thereafter in 2011, another recruitment rule was published where the quota was changed to 70 and 30, 70 for direct recruitment and 30 for the promotions. And the same condition of 6 years regular service was maintained in the 2011 recruitment rule as well. Now, these private respondents challenged this. When the direct recruitment notification was published, the private respondent challenged it, say that the prescription of that 6 years is not in accordance with the police manual. Because police manual has to be followed in this case, because all these vacancies were created prior to the publication of recruitment rule of 2011. And in initial DPC also it is written that there are 67 posts vacant, 27 for promotees and 40 for direct recruits. So on that ground, they challenged it, saying that this recruitment rules would not be applicable. The police manual should be made applicable in this case, and also the 5 years, 6 years that service in feeder grade should not be taken into account. That matter went up to the High Court, and High Court order is at page number 40.
Page 81 opposition of mine. Page 81
What is that? Page 81?
is the order of the High Court, as my learned friend was looking.
Order of the High Court.
50,
Page 81 of the writ,
No, no, my lord, my opposition.
opposition, page 81.
my writ is, it is, page number 43,
Which volume?
volume
No,
1,
my lord, since my opposition.
Volume
Better-
Not
better-
fixed earlier.
Better to follow the volume.
volume 1, page number 43.
Volume 1 টা দিন একটু। Okay, this is the affidavit in opposition.
My lord.
So I can take up the affidavit in opposition. এটা কি affidavit in opposition টা দেখি? হ্যাঁ? এটা কি?
My lord.
Affidavit in opposition টা দিন এটা?
ওপরেরটাই
এই উপরেটা মোটাটা, হ্যাঁ এটা। Affidavit in opposition.
ভলিউম 4টা বার করুন খুঁজে।
Okay, affidavit in opposition, which
Page
page?
81.
4.
Yeah, page 81.
In this, more or less the facts are narrated, and I am reading only from the second page of that. Page number क्या हुआ? 81. Page number 82, in the affidavit of opposition. In this, they have quoted, the Honorable Justice has quoted, the Andaman and Nicobar Police Manual 63 1963 came into effect from June 1, 1963. That is second para. And in last para, regulation 5.1 provides that promotion from one rank to another rank, one grade to another grade shall be made by selection, tempered by seniority, efficiency, honesty, and shall be the main factor governing such selection. So this just I'm just narrating the manual what it says. Next page, 83. Under chapter 5 of the promotion in the regular executive force, 7 lists shall be maintained by the superintendent of police. In one such list, that is the list D, names the assistant sub-inspector considered fit for promotion as sub-inspector are maintained. So now in this D list is very important for promotion. Where they are fit, then only they can be promoted. Under regulation 5.6, which was amended subsequently, no sub-inspector shall be considered eligible for promotion to selection grade unless he has put in at least 5 years of service in the rank of sub-inspector and unless he is fully efficient and competent to hold the charge of police station of importance, as he is fully efficient and competent to hold the charge of platoon or platoon commander. So this is the rules as per manual. List D, and they have to have at least 5 years of service in the police manual also. Page number 85. In that same order. Third paragraph. By issuing standing order such and such, the Inspector General of Police directs that an assistant sub-inspector at the time of consideration of his name must complete minimum 5 years of regular service and pass the upper school course from any police training institute. The Departmental Promotion Committee for promotion to the post of sub-inspector assembled on September 20, 2010. The Departmental Promotion Committee took into consideration the draft recruitment rules prepared on the recommendation of Sixth Pay Commission. Sixth Pay Commission recommended 6 years of experience for promotion from feeder grade to promotional post. So the difference is in the manual, it says 5 years, whereas in the recruitment rule, it says 6 years. The Departmental Promotion Committee recommended the names of 27 senior most assistant sub-inspector for considering promotion to the post of sub-inspector on ad hoc basis. However, as none of the recommended assistant sub-inspector possessed the required minimum service of 6 years, it was decided to take up the matter with the administration for seeking approval of competent authority for relaxation. Subsequently, however, recruitment rules of the post of SI has been framed and notified in on August 29, 2011, prescribing minimum service of 6 years. So this is the recruitment rule which was subsequently set. In this recruitment rule, the percentage of quota was changed to 70 and 30. So this 70 and 30 and this 6 years, there are two things under challenge. So now the issues are framed, which is at page number 91 of opposition, 91. Nothing to me.
Yes.
Now the issues are whether the administration before the promulgation of recruitment rules, that is the Andaman Nicobar Group B non-gazetted post of recruitment rule 2010, could recruit sub-inspector by way of direct recruitment. This is one question. And whether the administration was right in imposing condition of working experience of 5 years or 6 years for consideration for promotion from feeder post of assistant sub-inspector to the post of sub-inspector. So this 5 years or 6 years, 5 years is coming from the manual and 6 years is coming from recruitment rule. So finally, this page number 93. And 92 also, last two paragraphs. Therefore, it can be said that Inspector General of Police did not apply his mind in proposing 50%. There, it cannot be said that he did not apply his mind for proposing to fill up 50% post by direct recruitment. We have noticed carefully the list prepared, referred by Mr. Mandal being annexure R5. We notice that none of the assistant sub-inspectors are graduates. When two interpretations are possible, we prefer to adopt the interpretation which is beneficial to the interest of security of the state. Thus, we hold that proposal of police department to recruit 50% sub-inspector by direct recruit was approved by the administration, and approval was not only for the year of 1971. The second question is whether the departmental promotion committee was justified in imposing 6 years qualifying service for promotion to the post of sub-inspector from post of assistant sub-inspector. Now here, while deciding this issue, the issue framed is 5 years or 6 years. And in the initial paragraph, it was decided that they have power under the policeman. And now here the only the 6 years, which is the period prescribed in the recruitment rules, that was decided. 6 years.
And the first issue was not decided. It was left undecided.
5 years. 5 is not decided because
5 is not accepted, 6 is accepted. All right.
6 was considered for deciding this.
All right.
The departmental promotion committee, while considering the candidature of assistant sub-inspector for promotion to the post of sub-inspector, considered draft recruitment rules and noticed that excepting 2 of the candidates, none of the aspirants completed 6 years of regular service as assistant sub-inspector of police in Andaman and Nicobar Islands. And I am directly going to the final part, which is at page number 95 of the affidavit in opposition. Therefore, till the recruitment rules for recruitment of sub-inspector of police executive came into force, the post of sub-inspector of police executive are to be filled in 50% by promotion and 50% by direct recruitment, but imposition of condition of 6 years regular service in the feeder grade could not be imposed in absence of any provisions in the police manual. So police manual is upheld, but 6 years is not accepted. in as much as the recruitment rule came into operation only in January 2011. Subsequently, our recruitment rules of 2010 were replaced by recruitment rules of 2011 with effect from August 2011. Thus, we hold that in modification of the orders of tribunal, that imposition of condition of 6 years regular service in feeder grade by departmental promotion committee was without jurisdiction. Therefore, the order impugned stand modified. The recommendations of the departmental promotion committee, ignoring the candidature of these petitioners on the ground of not having 6 years of regular service, is set aside. Fortunately, now during the intervening period, 17 ASIs were promoted on ad hoc basis. For that, there is a finding here. Fortunately, the administration has given only ad hoc promotions to 17 persons out of 27 persons who have been selected by the departmental promotion committee. Therefore, no right has yet been accrued to the persons who have been promoted on ad hoc basis. The administration is therefore directed to take steps for filling up the post in accordance with law expeditiously. This order was not challenged by anybody. This order has attained finality. Now the issue is the administration has to fill up the post in accordance with law. In accordance with law means they have to fill up the post in accordance with the police manual, chapter 5.
Who were the applicants before this page 96, the order that you read?
The applicants were the private respondents.
Private respondents.
They challenged the direct recruitment. They stalled the direct recruitment at that point of time. It was delayed, and finally this order was passed. And this order says that all posts are to be filled up in accordance with police manual.
Yes.
After this, date, the first order which was passed is at page number 1911.
Page number
97. 97 of
Yes.
the opposition.
Yes, yes.
This order reads, on recommendation of DPC held on 2013, the following assistant sub-inspectors are promoted to the rank of sub-inspector on officiating basis. This is very important, my lord. On officiating basis against the existing vacancy in the pay scale of such and such with immediate effect. Now, this on officiating basis, it was done, might have done, because they were not having the requisite eligibility, they were not fulfilling the requisite eligibility criteria in the feeder grade of 5 years.
And this page 97, the persons are the private respondents?
Private respondents on officiating basis. This is the first order passed. After that date, one order is passed during the pendency of case, that is 11th June 2012, and this is the next order after the division bench order. This is the first order. So they have to fill up the vacancies in accordance with law, and this is the first order. And this is on officiating basis. Thereafter, the 31st May. 31st May उसको बता रहे थे तो
Direct to, that is 100
103 madam. This is the order passed in connection with direct recruits. The following candidates selected by the selection board constitute for the purpose are hereby appointed to the post of sub-inspector against the existing vacancy with effect from 18/5/2014. So now 18/5/2014 is the date when the direct recruits were appointed. And that officiating, before this, there is one order of officiating basis. That is And subsequently, okay, regularization go. 102. Page number 102. This is the order where those ad hoc persons were regularized. So now the judgment says they have to proceed in accordance with the police manual. Appointment should be made in accordance with the police manual. Police manual says, chapter 5 clearly explains what are the criteria for making a permanent appointment, and list D is mandatory for that. But here they have not prepared any list D. Directly they have regularized, and regularization is not a mode of recruitment in the police manual. And they have directly regularized them. And in their regularization order, the date is mentioned as date of regularization is 11/6/2012. This is directly conflicting the
Decision,
judgment.
division bench decision.
Division bench decision, because division bench has categorically said no right has accrued because of that 11/6/2012 order. So these are the three orders, which are basically 3 dates.
So earlier there was an officiating order.
Officiating order is another batch, another bunch of people. These 17 people are different. Those who are appointed on 11/6/2012 on ad hoc basis. This is one bunch. After the division bench's order, next another bench, another batch of 19 people were appointed on officiating basis. Now one order is ad hoc, then officiating, and then the regular appointment of direct recruit on from 18/5, and this again one regularization order of 14th August 2015. These are the 4 orders.
Page 102 is the regularization of the ad hoc promotees,
102 ad hoc promotees.
right?
Yes.
This set is completely different with page 97, who are promoted on officiating basis.
Yes. This is set. Oh, 11.
They are different.
They are different.
All right. And
Page 56 is the relevant page for 11/6/2012 order.
Seventeen.
Page 56.
Page 56, 11th June,
11
there were 17. And page 102, there are
16.
16.
One person they have not given. It may be some other reasons. So these are the 17 people. This they were regularized now.
Promoted to the rank on ad hoc basis. And this was during the pendency of the writ
And-
petition.
Pendency of the court cases
Hmm.
during the before the
Ad
CAT.
hoc basis, they can be.
The last 3 lines is very important. Is
Yes,
promotion being purely on ad hoc basis, they can be reverted to their substantive rank of assistant
ASI.
sergeant at any point of any time. And these officers will not have any claim or right to seniority in the rank of sub-inspector. This is very specific. So now what the officials have done, by order dated 14th August 2015, 102, they have
Hmm.
overridden this condition as well as the division benches order. So this is the issue, main issue. Now the provisional seniority list, directly I am taking to the provisional seniority list, sir, my lord.
Page 107.
Are the private respondents there in any of the lists, ad hoc or officiating?
Ad hoc also private respondents, officiating also private.
Some
respondents.
from ad hoc,
Some.
some from
Some.
officiating. All right.
Both are there.
Both sets. All
Oh,
right.
in both lists, their names are there.
Their
Some
name-
people, some persons. Page number.
107.
Page number 107 is the provisional seniority list. In this, the ad hoc appointees starts from serial number 54. Serial number 54,
Page 107,
page 108,
108, 54.
54. So in this, the columns are date of promotion, date of regularization. That in the heading, date of promotion and date of regularization. And in this, from page 54, date of promotion is shown as
11th of
11/6/2012, and date of regularization is also shown as 11/6/2012, whereas it should be 14/8/2015. That is the date where they were regularized. And another batch starts from serial number 67,
From 54, it goes down to which serial number?
66.
66. All 11/6/2012.
And another batch is from 67.
67 to
67 to
83.
So this, in this date of promotion is shown as 19/11/2013, and date of regularization is shown as
19/11/2013.
2013. So now this was not a promotion at all. This was only an officiating promotion, and there is no regularization order. It was not brought even till today on record that when these persons were regularized. So this was the issue. So there are actually in this, there was two problems in this provisional seniority list. Two batch of officers objected to it. One batch is at serial number 35 to 41. 35 to 41. Serial number 35 to 41. Actually, these officials, 35 to 41. Have you got my?
Yes.
Page 107.
Page 107.
Yes,
This
35.
35 to 35 to 41.
Hmm.
These are promotees actually. These promotees, in this, the date of promotion is shown as 17/12/2008,
Hmm.
and date of regularization is shown as 17/3/2009.
Hmm.
So these persons, they made a claim that our date should be from 17/3/2009 only, and we should be placed above 18, serial number 18. They have taken up the issue, and we have also taken up this issue that we should be placed above the ad hoc. Now they are saying that our seniority should be counted from date of ad hoc appointment, and we are saying that our promotion should be, our seniority should be counted from the above the ad hoc appointments. There are
So
two.
your appointment was not ad hoc.
No. This is two opposite cases. They are claiming that we should be placed above on the basis of ad hoc appointment.
Yes.
But we are saying that giving ad hoc appointment is wrong, that seniority from ad hoc appointment is wrong. It should be from the permanent appointment. So these are two
Your regarding permanent appointment, you come in a higher position.
higher position. So this was a two different scenario before the authorities against this provisional seniority list.
Yes.
Now, how they have dealt this issue? Two exactly opposite issue, how they have dealt. And
No,
that
prior to that 107, where are you placed? Which position are
they are
you?
from 84 onwards.
84 onwards.
84 to 100 and is 127. This is the direct recruits, but only few direct recruits are applicants here.
All right. But the batch is, it starts from 84 onwards.
84 onward until 126. That is the batch. So now this batch, the officiating
127.
batch is kept above us, and also the ad hoc appointees were kept above us.
Hmm.
So now how they dealt with the case of ad hoc appointees claiming their seniority from the date of ad hoc appointment. Actually, that paper is there in the आपको वो तो नहीं होएगा 607 volume 4.
One of the volumes 4 is missing. What is that?
So they have given a reply when they claim that they should be placed above. The reply what they have the authorities have given, that is very important in this
That
case.
is the decision taken by the authority on the representation.
On the representation of ad hoc appointees claiming seniority from ad hoc date.
Is it not annexed to the opposition?
No.
607 also.
Page
Page 607.
not in the
Page
opposition.
607.
Is it not there in the reply also?
Quoted in the interim order.
No,
No,
let us see the
it is
decision
not.
order.
It is not. 607. It is not there in anywhere
Hey,
because
true.
this I have placed it after the tribunal's order. I got this document as a discovery of new document. I produced it before the tribunal saying that this document is very important and vital to decide this issue. So this has not been considered. So in the review, I have brought it on record and said that the decision is to be taken based on this. And review was also dismissed. And now that review document is there with the writ petition. Page number 607.
607.
607. Now, have you got? This is the memo dated 11th July 2019. With reference to the representation submitted by the following sub-inspector against the provisional seniority list issued by such number such and such, they are hereby informed that their request has been fully examined but could not be considered in view of DOPT OM date such and such 2001 OM and rejected as they have no right to claim the seniority on the basis of date on which they are promoted on ad hoc basis. This is very clear. They have said 2001 OM is also annexed, which is at page number 608. First paragraph, fifth line. These instructions also provide that whenever an appointment is made on ad hoc basis, the fact that the appointment is ad hoc and that such an appointment will not bestow on the person any claim for regular appointment should be clearly spelled out in the orders of appointment. It should also be made clear that the service rendered on ad hoc basis in the grade concerned would not count for the purpose of seniority in that grade and for eligibility of promotion to the next higher. The OM itself says, and this is what recorded in the 11/6/2012 order. And they have explained everything and they have said, this is the position which is clear and the authorities knew it very well on that day itself. On this day, when this rejection was made, 11th July 2019, they knew it that from the ad hoc date, seniority cannot be given. But our rejection order is different. Our order also, our claim was also rejected. That is at page number 154.
113 it is there.
113
13.
of opposition.
That's July.
10th July. Again, this was rejected. They have quoted OM dated 3/3/2008 and reject. Now that OM they are very well aware of that ad hoc period should not be on the same date. This is on 10th and that is on 11th, next day. So this, they had the knowledge that ad hoc period, ad hoc appointment should not, that seniority should not be given from the date of ad hoc appointment. And here they have rejected our claim as well, where in our case, the ad hoc appointees were placed above us. This was our claim, and but we have said that it should be as per the rotation of vacancy, because we were not aware that when these ad hoc appointees were regularized, that order was not there with us. So we said that it should be based on the rotation of vacancy, like 50-50, one ad hoc, one promotee, one direct recruit. That is the norm which has to be followed. So this is the illegality which was committed by the authorities, and we have challenged it in the OA. But after this, we have made a then the final seniority list was issued on the next day. Like this, on 11th July 2019 itself, the final seniority list was issued. And final seniority list is same as the list of provisional seniority list. They have not changed anything. Final seniority list is at page number, what's that? Final seniority list,
Page 140.
114, 114, R15. All paginations in the list of dates, my paginations are there. This is also same thing. And we are still below the officiating, and so this we have made a representation against this final seniority list.
It is page 114. 114 page.
Page 114 is the
Confirmed
confirmed
seniority,
seniority list.
confirmed seniority of sub-inspectors.
Yes. In the before this, both the claims were rejected. That 2009 ad hoc appointees and 2014 direct recruits. Both claims were rejected, and they have kept the seniority list as it is and published the confirmed seniority list.
That is page 114.
114. And against this, we preferred a representation which is at page number
119.
19.
90.
119.
190.
So in this application was made on 22/10/2022, because between this there was a COVID period. 2 years COVID period was there. So there was a delay. It is to bring to your kind notice that my representation for re-examination of interstate seniority among direct recruits and promotees submitted against provisional seniority list has been rejected by memos such and such, placing reliance upon OM dated 3/3/2008. Subsequently, confirmed seniority list was issued on 11th July 2019. Recently, I came to know that another clarificatory OM issued by DOPT for determination of seniority, that is 2014 OM, wherein it has been categorically decided by the Government of India that OM 3/3/2008 is to be treated as non-existent, withdrawn, have been issued. So our rejection was based on 3/3/2008 OM, but whereas in 2014 itself, that another OM was there, by which it was withdrawn, which makes the confirmed seniority list finalized on the basis of DOPT OM dated 3/3/2008 erroneous and expressly illegal. So now we have asked in 2014 OM, that 2014 OM was issued based on NR Parmar case, where the rotation of vacancy and seniority in 1:1 issue 50-50 means 1:1 should be given. That was mentioned in NR Parmar's case, and it subsequently, in pursuant to that NR Parmar case, this OM was issued. So we have said that 3/3/2008 is already gone. So it should be on rotation basis. So we have asked that there should be one promotee, one direct recruit, because at that point of time, even at that point of time, we were not aware as to when these promotees were permanently appointed. It was not known to the petitioners here. So we have asked for this, and then again it was rejected at page number 122. 122, with reference to the representation submitted by following inspector for review and recall of confirmed seniority, hereby informed that their request has been carefully examined and not exceeded to in which view of DOPT OM dated 13th August 2021 and rejected as the case of seniority already settled. As per in terms of DOPT OM dated 86 and 86, 7286 and 3786. So they are saying that seniority is settled in terms of 86 OM. This is the contention. And our case was rejected. After getting this rejection, we immediately filed an OA challenging the final seniority list and this rejection order. And in the first round of litigation, the seniority list was quashed. But the problem there was the private respondents were not made the party. My submission before the tribunal was, since it is an absolutely illegal order, because 86, nothing was followed, no rules were followed. So therefore, it can be quashed. So it was quashed, and subsequently this private respondent came to this honorable court saying that they were not made party, and it was remanded back. It was remanded back. That order is very important for this High Court. 143.
142.
143.
143. No, we put one.
No.
Paragraph 12.
One.
There is no paragraph.
Paragraph no. Page 12.
This is a 5 pages order. Page 153, you say?
Yes. One minute. One 153.
It was remanded back.
My lord, page number 154.
Yes.
This second paragraph, it starts from, therefore submission of learned counsel for the petitioner is that in terms of the judgment of Jagdish Patnaik and also in terms of para 2.21.
Hmm.
This is the submission of the police manual. The seniority of petitioners are to be counted from the date of their permanent appointment regularization, which is much prior to the date of permanent appointment of respondents who were applicant in OA such and such. Therefore, it is submitted that since valuable right of the petitioners are affected, the impugned order. So based on this submission, the submission is the date of permanent appointment is prior to the respondent in that petition, writ petition, and who are the original applicants before the OA. And this, based on this submission, the order was set aside, the judgment of CAT was set aside and it was remanded back. And remanded back, and now finally the tribunal has passed an order, that impugned order. आपका उसमें कितना है?
169, 169.
169 no? 169. Page number 169.
Yeah. Relevant para?
It starts from 10, para 10. How it was?
192.
Now, here the finding of Honorable Tribunal is that, therefore, in our considered opinion, since the private respondents were regularized with effect from 11/6/2012 and 19/11/2012, there is no such order of 19/11/2012 at all, and 18/4/2014, and the applicants were appointed on 31/5/2014, that is after the regularization of private respondents. Now, 18/5/2014 is the regularization order. Other, there is no
The
1911,
previous two, there is no order of regularization.
no order of regularization. That was only ad hoc appointment saying that no seniority, they cannot claim any
So
seniority.
the category is ad hoc appointment, then officiating promotions, and the other is the.
Even this
regularization.
date is not correct. 19/11/2013 is the order, but it is mentioned. So this clearly shows that without any application of mine, this order was passed. And further, they have said, even their representation dated 16/4/2019 against the provisional seniority list dated 23/12/2016 was rejected way back on 10/7/2019. This is the rejection order of direct recruits. And next day, the final seniority list was published. And again, they filed another representation on 22/10/2012. This representation was against the final seniority, confirmed seniority list, but that has been missed here. That was a separate and distinct cause of action of challenging the final seniority
No,
list.
I know seniority list was prepared because the tribunal did not accept the contention of the applicants. Okay, this paragraph 10, after this paragraph 10 observation was made, final seniority list was published. Page 192, this paragraph
No.
number 10.
This all final seniority list is under challenge in our OA.
No, this page 192.
That was challenged, and this is the order.
This is the order. Hereafter,
Thereafter, no.
Yes, 192 is, we have challenged the
Seniority.
final seniority list.
final seniority list.
Final list seniorities and our rejection order of 5/3/2023.
Yes, the authorities, this is a rejection order.
Rejection order against the representation given
Yes.
on final seniority list. That is under challenge.
This is the findings of the tribunal.
This is the finding of the judge.
So after this, any decision taken after this tribunal's order?
No, then we filed a review was dismissed. Now, in the review, we have brought out that vital document which was never placed before the court, either by the official respondent or by the private respondents. This was there. So now, in that case, that promotees, they challenge it separately, and that has gone up to High Court. Coordinate bench has decided that they cannot get, and before the coordinate bench,
Ad hoc promotion, they cannot get the
they
benefit.
cannot get, and before the coordinate branch, the official respondent stand was the same,
What?
that ad hoc period cannot be counted for the purpose of seniority. That is same, and that judgment, I will place that judgment also. And now coming to the rules, what 2.21 and there are two rules of police manual with respect to the seniority. 2.21 and 2.25. That is 432 and 433 in my volume 3. (432). My lord, I've got 432.
1 minute, prior to going further, 192, you were at 192.
right? The order of the tribunal.
Hello.
Paragraph 10 you placed. And thereafter, paragraph 11, it mentions that the official respondents have rightly granted seniority vis-a-vis the private respondents as per their respective dates of regular promotion.
Yes,
But here, the ad hoc is taken into consideration.
ad hoc is taken into consideration. Ad hoc and officiating is taken into consideration. And these rules were the rules which I am placing now. It was before the tribunal also. I have placed it then there also. 2.21, page number 432.
Yes, seniority.
Seniority. The seniority of a person in any rank or
Is it
category.
there in the opposition? Is it there what your learned friend is placing? 4.2 rules?
No, no, it is.
It's not there. Volume 3.
Volume 3. Volume 3, page number 432.
Yes.
This is police manual in the order passed by coordinate bench on 15th of July 2013. The manual is to be followed. It was categorically mentioned. So this is the manual 432 2.21.
Hmm.
The seniority of a person in any rank or category or grade shall, unless he has been reduced to a lower rank, to be determined by the date of his permanent appointment to such rank or category or grade. If any portion of service or person does not count towards, so that is not, this is the main thing. Permanent date of permanent appointment, that is what they have said before this court while remanding back the matter, 2.21. This is the permanent appointment date. It should be permanent appointment. And now 2.25 is next page, 433. Four hundred and 2.25. The following principles will be observed in determining the seniority of officers in the same rank. Officers who are officiating or on probation in any rank or grade take the seniority below the officers confirmed in the rank. So this is also there. 2.25. So now both the orders of officiating
Unless it is confirmed, that will not be taken to be
In the
regular
seniority.
promotion
regular
for the
promotion
purpose of seniority.
for the purpose of seniority. Seniority rule is specific.
Confirmed promotion.
Confirmed promotion. So permanent promotion, permanent appointment is very important, and in officiating promotion is also allowed by the police manual, but their seniority must be fixed below the people who are confirmed on that day. So this is the rule. I have also placed the judgments which I relied upon before the tribunal itself, but tribunal has not taken into account any of the judgments, which I am placing it now again. First judgment which I have placed before the tribunal was at page number 584 in volume 4 actually. 584.
Volume 4 is পেলেন ভলিউম 4টা আপনি কি হ্যাঁ কোথায় থাকবে আর কোথাও থাকতে পারে দাদা আমি জানি না Obviously, one of the volumes is missing. Volume 4, there is only one copy. Sure. It must be there. How can he has submitted copy of both volumes in others? How can volume 4 be missing?
দেখে নেবেন।
হতেই পারে সব ভলিউম 4
Yes, 584.
yes
584. Paragraph 29.
yes hmm.
here one of the objection which was taken by the private respondent was delay. Because the final seniority list was published in the year 2019. And the representation was made in 2022. And it was rejected in 23, and soon after that we filed a OA. So now this is very important judgment. Thus, in view of the above, the settled legal proposition that emerges is that once the seniority list has been fixed and it remains in existence for a reasonable period, any challenge to the same should not be entertained. In KR Municipal Supra, the court has laid down in crystal clear words that a seniority list which remains in existence for 3 to 4 years unchallenged should not be disturbed. Thus, 3 to 4 years is the reasonable period for challenging the seniority, and in case someone agitates the seniority list beyond this period, it has to be explained for the delay and latches. So 3 to 4 years the window. Now, in our case, after 2019, that issuance of confirmed seniority list, soon after that, COVID started. For 2 years, there is already an exclusion by so moto case. So moto case also I have annexed here. So moto case 2 years. So exactly the 1 year and 8 months is the delay. And 1 year is allowed by tribunal in any case, but 3 to 4 years is the window which is kept open for challenging the seniority list. So it is well within the time. Only thereafter the explanation is required. We moved the original application before the tribunal after the rejection order within the 1 year period, statutory period of 1 year, so that there was no delay at all. And second case was, which I relied was K. Madalai Muthu, which is page 611. In this 617 is the relevant. Now, I am reading from 12th line from bottom of the third paragraph, big paragraph. It stands to the reason that a person who is appointed temporarily to discharge the functions in a particular post without recourse to recruitment rules. Now, without recourse to recruitment rules is police manual. That initial appointment was based on draft recruitment rule. In that also they were not eligible, and the police manual says 5 years. So as per police manual, they were not appointed. So it is clear that they were not appointed anywhere in terms of the recruitment rules. Cannot be said to be in service till such time his appointment is regularized. Therefore, it is only from the date on which services are regularized that such appointees can claim seniority over those appointees subsequently. In the instant case, the authorities, on the strength of several government orders giving retrospective effect to the regularization of the promotees, have taken the date of initial appointment of such promotees as the starting point of their seniority. In our view, such a course of action was erroneous and contrary to the well-established principle relating to determination of seniority. So this point was cleared here, that even if it is retrospective, the promotion is retrospective, that period cannot be counted for the purpose of seniority. And another judgment is 618. In this 618 last paragraph, in the case, admittedly, the promotion of respondents was not in accordance with rules, but they were delayed on ad hoc basis due to exigency of non-availability of direct candidates. Thereby, it is clear that the respondents were not promoted according to the rules. In other words, they were promoted rehouse the rules. Though they have continued for a long time, the entire length service should be considered as fortuitous and should not be counted towards their seniority. It is also clear that that period cannot be counted for the purpose of seniority. Now, next case which I have taken is at page number 620. 620 is, this is the case of that promotees which went up to division bench. Para 12. This is the stand of the authority. It is further stand of the authority that since the promotion was on ad hoc basis with a clear stipulation that they will not claim any right into seniority and may be reverted to their substantive post, such ad hoc appointees cannot be counted for the appointment cannot be counted for. This was the stand and they have succeeded. And this order is binding because they have taken the stand.
So unless the root question then comes is unless there is a regular promotion,
Yes.
there is no question of
Rules does not allow
unless there is a regular promotion.
regular promotion. And in the another Delhi High Court judgment, which 637 I have annexed. This says about the police manual, that list D. Without list D, there cannot be any appointment, recruitment, it's promotion itself. This clarifies that position. My lord, initially before the tribunal, this was a case based on the OM. So now that OM also is to be referred to. OM 4th March 2014 is at page number 59 of my volume 1. 59.
Is that OM there in the opposition? It's not there.
I am directly going to page number 60, relevant portion. So this is in the matter, the matter was examined in pursuance of Honorable Supreme Court decision in NR Parmar in consultation with Department of Legal Service, and it has been decided that the manner of determination of inter-se seniority of direct recruits and promotee would be as under. Now in the first subpara A, that 3/3/2008 is treated as non-existent, withdrawn, or been issued. It is clearly mentioned. And now B, the rotation of quota based on the available direct recruits and promotees appointed against the vacancies of recruitment year as provided in DOPTOM 86 and 87 to 86 and 3786. This would continue to operate for determination of inter-se seniority. So the 86 OM is continuing. There is no this thing that there was slight variation, but I am harping upon this point only. And the next point, that 86 3786 OM is at page number 62. The 2.1, the relative seniority of all direct recruits in the is determined by order of merit in which they were selected for such appointment. And two point three, where persons recruited or promoted initially on temporary basis are confirmed subsequently in the order different from the order of merit indicated at the time of their appointment, seniority will follow the order of confirmation. Here also the confirmation is given importance. And 2.4.1, the relative seniority of direct recruit and the promotee shall be determined according to the rotation of vacancy between direct recruits and promotees, which shall be based on the quota of vacancy reserved for direct recruits and promotion respectively in the recruitment rules. Now,
So these promotees means regular promotees, not ad hoc promotees.
No, that is clarified later on.
That is direct recruits and
Now-
regular promotees.
Regular promotees. Regular date rule 2.21 says date of permanent appointment. Seniority should be counted as per the police manual. The OM also says so. 2.4.2. If adequate number of direct recruits do not become available in the particular year, rotation of quota for the purpose of determining seniority would take place only to the extent of available direct recruits and the promotees. In other words, to the extent direct recruits are not available, the promotee will be bunched together at the bottom of seniority below the last position up to which, and this is the illustration they have given in the last, where the recruitment rules provide 50% of vacancy of the grade to be filled by promotion and remaining 50% by direct recruitment. And assuming there are 10 vacancies in the grade arising in each of the year and year 86 and 87, and that 2 vacancies intended for direct recruitment remain unfilled during 86, they could be filled in 87. The seniority position will be as under. Now, in this, what happens? That P1, D1, P2, D2, P3, D3, and since direct recruits are not available, P4 and P5 are bunched together for 86. And now it comes 87. 87 again, P1, D1, P2, D2, P3, D3, P4, D4, P5. Then 3 direct recruits are bunched together. So now in our case, what happened? 2014 is a permanent appointment. In our case, and there was no permanent appointment in 2014 at all.
No direct appointment.
Direct appointment, we are direct appointees. No permanent appointment was made in the case of promotees in 2014. So in 2014 seniority list, we ought to have been bunched together. And their permanent appointment happened in the year 2015. One lot of persons who were initially appointed in the year 2012 as ad hoc, they were regularized in 2015. So in 2015, their name will come. They will be bunched together. If at all, that regularization should be taken into account. And the other set of persons, that 19th November 2013, they are only on appreciating basis. They have to be kept below the confirmed person in all circumstances. So this is the OM.
That means on the date of your direct appointment, if there is no regular promotee appearing in the available in the list
In that year.
or on that particular time when you are directly appointed,
Yes.
nobody, no ad hoc promotees cannot come into that category.
Yes. And that interspace won't be there. That entire direct recruitees should be bunched together in 2014 year of seniority list. And then only the 2015 seniority list will come. Now they were appointed in 2015. Their placement cannot be above 2014 direct recruits. I am placing 2 more judgments. Sir. In this case, there was a violation of statutory rules. So now I am reading from paragraph 34 and 35. 34 from the middle. Thus, again, the seniority list was finalized in the same sequence as the as 3 lists which are received and in that order. It is thereafter that the representations are made that seniority list of direct recruits of 2001 was wrongly prepared contrary to the rules. However, when no action was taken, such and such and 14 others approached High Court, which was within a period of 2 to 2.5 years. Until such time, they had been pursuing their representation after office orders such and such. From the above facts, it is clear that in first contingency, or in the second contingency, the appellants cannot be found at fault. The division bench committed an error in holding that the claim lodged by appellant suffered from delay and laches. The plea to defend the seniority list prepared contrary to the statutory provisions on the ground of delay would be a difficult proposition. Apart from the submission of appellant that there is no delay, as they came to know about 3 separate lists only in March 2010, even if it is assumed that there are some delay in and a fresh seniority list was prepared in 2009-10, again contrary to the provisions of statutory rules, such seniority list cannot be sustained or defended on the ground of delay of 5 years. So this is when it is violating the statutory rules. It is based on the principle of there cannot be any estoppel against the statute. So then the time is immaterial. How the authorities act in violation of their own rules. But I have covered all aspects. So in case of any requirement, I will reply.
In the reply, you can fill in if there is anything to be taken care of.
My lord.
All right. Now, I just want to check up that the primary reason for disallowing your writ was the ground of delay,
Delay.
isn't it?
Delay and that regularization dates were wrongly written there.
Regularization dates are wrongly written.
These are the
Those
two aspects.
regularizations were not upheld by any court or tribunal. Those regularizations.
This is the first time we are coming. And in their earlier order of this honorable court, when they remanded back the matter, when the private respondent approached, they have relied upon 2.21. And they said that their date of permanent appointment is earlier to the private respondent, like original applicants. That is their judicial admission. Now, actually, that is a wrong fact. It is not correct. The permanent appointment of private respondent is in 2015, 14/8/2015, whereas our appointment is 18/5/2014. And one batch of private respondents were never appointed
So this is
permanent.
factual mistake according to you.
Yes, yes. Ma'am. Wrong recording of facts.
So out of the judgment, which is of 25 pages, it is only paragraphs 10 and 11 which deals with merits, and other things are the factual aspects that have been set out.
And final finding on factual facts is
There is no discussion, nothing of the sort. All set out, set out, set out.
one more thing. The tribunal has said that there is no challenge to the order of 14/8/2015, which says that regularization is retrospective effect. My submission was that I am not challenging that order. I am challenging only the seniority list. How the seniority can be granted from 11/6/2012.
What basis?
On that is citing Madalai Muthu, it is clarified that even if it is a retrospective promotion, that period, that the seniority must be counted only from the date of regular appointment.
Regular appointment either directly or by
By
regular.
promoting, both. It should be, in both cases, it should be regular appointment.
Whether direct or promoted.
direct or promoting. So they must produce a document to show that when they were regularly appointed. That is only the 18/5/2015, after our regular appointment. So, but they were placed above us in the seniority list, which is wrong. And another set was never regularly appointed. It is only on officiating basis. Rule 2.25 will come into play.
Do we hear you on the next day?
Only one thing, my lord.
But I have very
Document check in
limited-
advance.
that was not the
case
phase before the
trial.
trial.
What was the case? My learned friend came to the court in the year 2023 saying that NR Parimar, the ratio is that 50% direct, 50%
50%
by, that is
promotion.
1:1 ratio. That was the case made out before the tribunal. By that time, my learned friend filed this writ petition. Already in the year 2019, that judgment was overruled by the Supreme Court. And this all argument which has been advanced, that was not the prayer, that was not the case, that was not the ground.
Is this the reason as to why there is no discussion in
Yes,
this
I-
My lord,
judgment?
because the Mega Chandra when came, there is a protection given to those who are done in NR Paramar. So the Mega Chandra has been followed by the authorities.
The very purpose of filing the case was on the basis of a judgment of the Supreme Court.
Supreme Court.
That was already overruled. And this argument, my lord, we
This
advocate.
is what I was seeing, that there is
No,
nothing
we advocate,
recorded
we
in the
have the priority
judgment.
that we can argue anything.
That is, but it should be reflected.
It was not the case, my lord, their plain,
My
their
lord.
case may be seen, their ground, I will place 106 and 107 is the ground. 50%, 50%
50%.
NR
That is
Parimar.
NR Paramar.
NR Parimar, when they filed, that was overruled.
Subsequently,
My
one
lord,
that
this argument,
86.
my learned friend has-
86.
now my learned friend shall not be allowed to argue further.
no.
Because
80
this was not the case.
In Mega Chandra, 86
Now, my
OM
lord,
was
Our
upheld.
appointment order,
In reply.
yes,
You
our
finished your
appointment order,
piece?
our promotion order, regular, nothing has been challenged.
Challenge.
My lord, the provisional list which was issued in 2016, that they raised objection in 2019. That was rejected. That rejection never challenged. And in their petition, writ petition, para 12, they say we are aware of the said provisional list of 2016. Since then, it is their pleading. Now, my lord, a person cannot, at his whims, he will come to the court and want everything to be disturbed. And this was not the case made out, my lord. Tomorrow, my lord, let it be.
Let us, yes.
Yes.
The next day will. Please come. Learned advocate representing the petitioner commences and concludes argument. Stop. List on Monday for hearing the respondents. আপনি এগুলোকে বার করে রাখবেন। বুঝতে পারলেন? Yes, সবকটা ভলিউম, সেকেন্ড জাজেস কপি, ফার্স্ট জাজেস কপি সব আলাদা সরিয়ে রাখবেন। একটা কপি অফিসে কি করে পড়ে থাকবে?
ভলিউম দুটো সেটে আছে না থাকলে দেখবেন অফিস থেকে আছে কি
রাখো। Yes,
This is a case, my lord, against an order of dismissal, my lord, arising out of a departmental proceeding which suffers from, my lord, illegalities and irregularities. In a brief campus, my lord, I'm giving the outline without opening the, my lord, file. But the petitioner before my lord, born in 1967, but he passed 10th standard examination from CBSE as a regular student where his date of birth was recorded. Thereafter, my lord, he made an application before the authority for the purpose of employment as a draftsman. My lord, his candidature was verified, scrutinized, he was interviewed, ultimately selected and got the employees. After 31 years, my lord, a charge sheet in 2019 was issued alleging that his date of birth, my lord, in the school register was something else. So he has a false date of birth. Accordingly, on that, my lord, two charges, my lord, the disciplinary proceeding was started. But I attended the inquiry proceeding. My lord, and one more thing, my lord, I should submit. This, after 31 years, this was done, my lord, in pursuance of a private criminal, two private criminal complaint, my lord, made that the date of birth was false. Two private persons, my lord, did it. But out of animosity or otherwise, my lord, I am not on that. Out of those two criminal proceedings, my lord, one has been set aside, my lord, because both the complaints were on same set of facts. Two different persons did it. And that criminal proceeding is yet to be finally adjudicated upon. The documents disclose that some documents were impounded by the authority, which was placed before the learned court below, criminal court. That is yet to be admitted as, my lord, evidence. So this is there. Under such circumstances, my lord, the departmental proceeding was started. But I participated. The inquiry authority, my lord, after inquiry authority, my lord, examined some witnesses in respect of those documents, my lord, which was, my lord, yet to be exhibited all on those documents, but with a different person, not the signatories of the documents. I made an application, my lord, for production of defense witness, including those persons. Those were rejected. I prayed for inspection of original documents, that was not given. I was handed over the documents, certified copies of the certified copies, rather the Xerox. Those were produced to me. Then, my lord, when none of my prayers were taken, I made a representation for stall of the inquiry proceeding before the inquiry officer. It was not heeded to. Then I made, my lord, a representation before the Lieutenant Governor. It was pending. And since my prayers were rejected, my lord, from the order sheet, it would appear that the inquiry officer recorded that since the charged official has failed to obtain any stay from the higher authority, proceeded, concluded the my lord, inquiry proceeding, and, my lord, the prosecution, my lord, submitted, my lord, the presenting officer submitted his defense statement. In that way, my lord, completed. In the meantime, my lord, I challenged the order of suspension, prolonged suspension before the learned tribunal. That was pending. Then, my lord, again, I challenged for continuance of simultaneous proceeding of criminal proceeding as well as the departmental proceeding. That was, my lord, taken up for hearing on 28th of February 2020. On contest, my lord, an order was given because there are two judgments were cited. My lord, keeping in mind even the Paul Anthony's case, two judgments were cited. The learned tribunal directed the authority, my lord, that should be considered. It was not considered. one important thing is the representation was made before the Lieutenant Governor on 21st of February. Now, subsequently, it transpired, my lord, that during the pendency of the representation before the Lieutenant Governor, my lord, the inquiry report was submitted on 25th of February 2020, behind my back. I was not aware of that. I was never served with that. My lord, and my lord may remember, in this case also, my lord, COVID came into play. Containment zone was declared. It was not served upon me. Then, my lord, an order of the authority was passed on 28th of April 2020. That was not also served upon me. It is the case of the respondents that they tried to serve upon, but I was not found in my place, my quarter. That is their case. It is also their case that they pasted the order of 28th of April 2020 on my door. And in fact, my lord, I was in the place of posting itself. Because of the containment zone, I was not there because I was alone there. My family was not there. So, it according to them, but it was admittedly, according to them even, it was their case, that it was pasted on 30th April. I came to know the order of dismissal, my lord, from a newspaper notification dated 1st May 2020, which was published. Now, another important aspect is, my lord, according to the respondents, my lord, on the basis of their accepted date of birth as 1960, I was supposed to retire on 30th April 2020. So, your lordship will consider that on 1st of May, which was circulated, and that a copy of the order of final order, it was not served upon me while I was employment according to them even. This is one aspect whether that can be done, whether if according to them even a master-servant relationship ceases, whether that order can be given effect to or not, or whether the continuance can be given. This is one aspect of the matter. Then, my lord, I made an appeal. And the appeal was preferred, it was rejected, then I moved before the learned tribunal. One important more thing, my lord, I was about to forget. The representation, my lord, of before the Lieutenant Governor for change of the inquiry officer or stay of the inquiry officer on the ground of bias and as well as the simultaneous proceeding, it was, my lord, allegedly decided by the Lieutenant Governor of 23rd of March 2020. Whereas the inquiry report was submitted on 25th of February 2020. But that I could come to know, because that order was also not served upon me, that I could come to know when the respondents, my lord, filed a miscellaneous application on the disposed of matter regarding that stay of simultaneous proceeding in the matter. Now,
Tell us one thing, what is the document
yes,
which you relied upon
yes.
in support of your date of birth at the time of getting the job?
But a CBSE certificate as a regular
CBSE
student. Yes, my lord. That is there, they inquired. It is written in the application form even. That
And-
I was a regular student of CBSE and my date of birth is recorded in as 1967.
BSc certificate.
Yes, yes, CBSE
Right.
certificate.
And-
This is there, there can be no
Is,
doubt of.
is that an, is the finding of the, is the recording of the CBSE challenged anywhere?
No, never.
What is the stand of the private party when they say that the date of birth is
Private
lawfully
party, my lord, challenge on the basis of some school transfer, alleged school certificate, transfer certificate. Because I was changed. My father was in employment. He was there on transfer. I was coming while I was minor. It was done, my lord, at that point of time.
But before
It
the
is not that when I attained the majority or otherwise I did so.
before the CBSE authority, the age which you have
Yes.
filled up, that was relied upon by you,
Yes, that is relied upon by me.
reflected in your certificate.
And then my lord knows, my lord, the judgment delivered by our then Chief Justice Desai, my lord, in 1990. That when all these things are there, relying upon a judgment of Sishu Ranjan Das, my lord, that the CBSE school certificate is accepted. This is one aspect of the matter. My point would be the procedural irregularity right from the very beginning. Admittedly, my lord, the inquiry report was not given. It came to me only, my lord, when the dismissal order was passed. But there was inordinate delay. It's not that even you will also kindly see the criminal complaint was lodged in 2009, 2010 by the
Who are
private.
they? Who are those private persons? Your
The
relatives?
persons I had, my lord, some sort of animosity because I.
Are your relatives? How do they
No,
get
they are
to
not
know?
related. They are not related.
How do they get to know, or how do they get the
Possibly, my lord.
benefit of
My
these?
lord, they are, my lord, local in this area, my lord, knows.
They get to know your school leaving
Yes,
certificate.
yes, somehow, my lord, that is there. That is there, but that I cannot explain. How they do get to know, because
There are other documents regarding your Aadhaar card and this voter
No,
card.
all these
Different
things-
dates are mentioned.
No, no, they are, my lord, also the date of birth, my lord, will find as 1967.
Yes,
Below.
why are you smiling?
But these are, let me say, other they say that this is not the
Carry on,
factual aspect.
carry on.
This is not the factual
Lord,
aspect. Then let him finish.
Yes.
That
My
will
lord, this
be,
is there. Now, my lord, my lord, 3 matters were in fact pending, including a contempt matter, my lord, for non-compliance of the order for consideration of the stay of simultaneous proceeding before the learned tribunal. But initially, by the earlier bench, my lord, the matter was CAP. I submitted a written notes on submission. But because of transfer of the learned judicial member, it was delisted from the list of CAP. Matter again appeared before the bench. It was not taken up. Then, my lord, when the lastly taken up, I submitted categorically. That is the misfortune on my part. I categorically submitted before the learned tribunal. But, my lord, I am arguing on the contempt matter only. If my lords are with us regarding contempt, then all subsequent action will go. That was my categorical argument. And if my lords are not with me, then I shall argue on disciplinary proceeding. Unfortunately, when the judgment was delivered, my lord, this submission was not at all recorded. The day the judgment was delivered, the very next day, my lord, I went there and I mentioned the matter. Well, look here, it is not recorded. I cannot do anything. You challenge because we hired. At that stage, my lord, I filed this WPC. Now, my challenge, basic challenge will be that, and my lord, from the judgment of the tribunal, my lord will find that even the written notes which were on record, the judgments which were on record, have not been taken into account, save and except 1 or 2 judgments. All the judgments which were recorded, my lord, were only of the respondents. It was not at all recorded, not at all taken into account. Because, my lord, the basic thing you will also can see the charge sheet, there has been inordinate delay. Charge sheet was issued after 31 years of service. Then, my lord, second thing is, even if it is assumed, though not admitted, that there has been some change of date of birth while I was in school by my parents. Whether that can be a fundamental to issuance of a charge sheet after 31 years, regarding which I had no role. Thirdly, whether there has been utter irregularities and illegalities insofar as the disciplinary proceeding is concerned. My lord knows Karunakar's case. If the inquiry proceeding is completed, my lord, an inquiry report has to be given to, my lord, have the incumbent his say in the matter. I was, my lord, denied of that opportunity because, my lord, you may remember after Ramjan's case, my lord, in 1994, my lord, this Karunakar's case came into play. This is there. And the most important thing is also, my lord, that the school living certificate, my lord, clinches the issue. Where everywhere it has been accepted. But this is the case in a nutshell, because today, we are running short. Only thing I would, my lord, submit a short written notes on argument, my lord, and if my lords so directs, I can make my lord submission online, my lord, from there only. And I'm just handing over my comprehensive list of dates, short list of dates, not in details. If a details list of dates is there, if it is required, I can hand it over. Let's see serial number 1, date of birth. I have given, my lord, where it is there. Serial number 2, my lord, is the FIR. Two FIRs, my lord. Serial number 3 and 2 and 3. Serial number 4 is the charge sheet, my lord. That will appear, my lord, at page 451, 452 of the, my lord, paper book.
Please show us this, your date of birth, the CBSE certificate.
Yes, my lord. I'm just saying.
Chapter volume. 4 volumes.
I will kindly take volume 4.
Yes, volume 4, page 464.
464.
এটা কিনতে স্যারকে তুলে দিন।
Volume 4. দিন ভলিউম 4টা যাই হোক একসাথে আছে। ভলিউম 4, 5, 6 একসাথে যাই হোক দেখে দিন 4টা। Actually, but broadly, at the before appearing in the examination, there is a condition that rules have been dispute with regard to age should they make necessary change. So once it is entered in the school final, that solves. And that is the final. No question of any further. Right on.
67, it's 4th December 1967, isn't it?
Yes, madam.
Page 464.
And the next page is, my lord, the mark sheet.
Mark sheet, the date of birth is not mentioned.
No, no. Still, my lord, I have annexed it. Date of birth is not mentioned.
No, it is only in the
Only the marks which you have got.
admit card, you get this.
4th December 1967.
And what is the date or the document relied upon by the private parties to say that the correct date of birth is something else?
My lord,
What is that document?
wants to see this 888 paper of it.
And these,
My lord, this is
concerned with his parents, then only he will record the date of birth. How will you know his date of birth?
Please show that.
I'm saying, my lord. That, my lord, will find from page 455.
465.
455. 454. Sorry, no, 455.
No, 455 is the charge sheet. Articles of charges.
But they are, my lord, they have relied on those
Documents.
documents.
Where is that document?
Lord, in the affidavit reply, I have enclosed.
In the opposition?
Yes, ma'am.
Where is that document?
My lord, may kindly come to this affidavit in reply on behalf of the respondent.
Reply name, one Gama আছে.
46 it is there, no?
Page 46
Yes, ma'am.
of your
40
opposition.
Yes, ma'am. 45 it starts.
45 it starts. Page 46.
Students transfer certificate.
Yes, no.
Date of birth is 60 and here it is 67. 7 years difference.
Lord, he,
7 years.
Lord, what has happened when he has joined some other school and they have issued a transfer certificate. After a certain break, he again joined with some other school, whereby he manipulated a certificate saying he was 67. So that's such, when he admitted in 9th, thereafter he completed 10th. And the school authorities, that is one part. Other part is the draft man certificate, diploma and draft. That also fake. The principal of the college has come and deposed before the proceedings.
That is different.
That is
this
also
is-
charged.
That is
No,
from,
right now it is the date of birth that
Date
we
of
are
birth and as
looking
well as
into.
the fake certificate he has produced to open.
That will see
this-
fake certificate, but
Fake
then
certificate of CBSE.
No, my lord, with regard to the diploma in draft engineering.
that will see.
Yes.
But here it is 1960. Date of birth recorded. Amos.
one of the question would be whether I have issued a fake certificate of no or not. Can it be a subject matter of departmental proceeding or in the criminal proceeding?
Criminal case is pending, my lord. The
Yeah.
charge sheet has been filed.
So unless and until it is established by a competent court, criminal court, that it is a fake document, whether I can be subjected to this punishment.
The department proceeding prima facie if it establishes on
Will
record.
we hear you?
Yes.
Now, 264 is a short of the short.
As per declaration ICSE.
And
Basic
declaration for others.
Any কোনো dispute?
For dispute name.
The other documents is voter cards, Aadhaar cards, PAN cards, what was recorded?
That I have not. Any is not. That I have not. Any.
Date of birth, it is school certificate.
Leaving certificate is being marked.
No, তারপর ওনা ফিটিংসটা বলে যাবে যে কি করে 50 জায়গা 50 জায়গা এরকম জানলে তো তার কোনো হাত নেই সার্টিফিকেটে সে বাবা মার কাছে থেকে যেটা বলছে সেটাই ছিল না অন্যগুলো যেন আছে মানে ভোটার কার্ড আধার So this they are not disputing to be fake. This certificate.
This is the other.
That will not help.
Aadhaar card same age is recorded.
Yes. Ah, Hirot. Right. happen.
Even from the voter card also, my lord, it would be
Yes,
the age of age, my lord, date of birth is of 1966.
yes. And by now you have retired from service.
Madam, well, I have been dismissed. Had my age been considered as 67, I would retire in 27, early 2020.
27. You
Yes.
would have been in service.
If it is 67, then 60 years, my lord.
Ah,
But basic, my lord, we initially considered, my lord, above all, if the procedural irregularity is there, whether the departmental proceeding can be sustained. Only one thing, my lord, the judgments, my lord, I have,
No, we'll
Even
go
when
to
it-
the judgments later on. First,
no.
factually.
yes, yes. This is the factual aspect, my lord, I can, my lord, now, one after another.
Yes. Show us the judgment of the tribunal.
Tribunal, yes.
এই 60 যদি এর পাস হয় তাহলে 26 বছরে সিবিএসই পাস করছে এটা নিশ্চয়যোগ্য হতে হবে 26 বছরে সিবিএসই পাস করবে যদি বলি বলে তাহলে হ্যাঁ তাও একটা কাবু একটা 26 বছরে গিয়ে ফুটবলার পাস করছে
It's a lot of difference.
But page 6.
তারপর তো সাপোর্টিং অনেক সময় রেশন কার্ড পরে সেটা একসাথে সবাই বছর সাইন ক্লাস 10 পাস করে প্রাইভেট age আর একটা সার্টিফিকেট
I will kindly come to page 22, first one.
of your writ petition.
Yes.
Yes. Now, my lord, can you see the number of cases over there? And I was submitting that, my lord, in a miscellaneous application. That was for the first time disclosed is, my lord, MA 306 of 2020.
Hmm.
I simply submitted on, my lord, the contempt petition CP 34. And unfortunately, it didn't go into the recording that I didn't make any submission on departmental proceeding even. Not a single argument has been, not a single sentence rather.
All right, in the judgment,
Yes, my lord.
uh, the charges are mentioned.
Yes, yes.
Article 1 is your date of birth.
Yes.
Article 2 is your fake certificate in diploma.
Yes.
These are the two charges.
These are the two charges.
Where
but
is
fake
the,
certificate in so far as diploma is concerned, is cannot be the issue.
show us the certificate once,
Which certificate? Diploma certificate?
diploma certificate, which is said to be fake.
Article 2.
Article 2. 1990, draftsman grade 2.
That was mentioned that document I do not have. That they have relied upon, they have.
Where is your document? Where is your certificate?
But that document, alleged document has been seized by the police. It's not-
Photocopy, nothing of the sort.
Nothing
You
is
do not
there,
have
nothing is
anything.
there, nothing is there. They relied upon that, my lord. It is before the learned magistrate.
Oh, with regard to that fake documents, a criminal case was instituted against.
Yes, 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 yes.
Was on the same issue disciplinary proceedings instituted?
Yes, on that basis, Malad, the
Same,
disciplinary-
same issue.
Yes.
এই তো issue তো এখানে হচ্ছে।
And one more thing, your lordship, can you see, salutary principle. Even if the document is there, appears to be, my lord, tampered. If no benefit is derived from that document, it, in the eye of law, cannot be said to be, if, rather, cannot be charged with the person concerned to be of forfeit. Yes.
That is a different thing, will not go to that extent.
Yes.
You have this birth certificate, class 10 CBSE certificate you have annexed.
Yes.
And this you
Whatever
didn't have.
document I have annexed fine.
You didn't have a single photocopy of the
No, no, I don't-
draftsman grade 2
but I
certificate.
do not have, my lord, they have.
With regard to Article 2, what is the findings? That is the fake.
No finding
No,
has yet been received.
In the inquiry proceeding,
Yes,
where the person concerned was called,
yes.
he was not the person concerned who offered the document on the basis of which they are relying upon. And those persons I have, my lord, prayed for production as a defense witness in the inquiry proceeding. Say, suppose, my lord, one principal, my lord, has offered a document.
Yes,
For the purpose of deposition, they have called on the vice principal. I
The
do not
school
know.
the records of this institute? Polytechnic College? The Polytechnic College?
I cannot have any access to that. one.
No, whether they were
No,
verified.
on the basis of the, my lord, communication itself. A communication was made as it was.
Where is that communication show us?
That is in my learned trade
No,
copy.
it must be there in the
Lord, page
the affidavit in
64,
opposition.
no,
opposition.
page 264. The
Yes, it should have been
Page
there.
the
64.
school authorities, my lord, the college has
Yes,
said,
my-
here,
my-
the admission number which is given, that is not the admission given by the institution. And they say,
Wait, page 264.
yes, my lord.
Every place, every witnesses, my lord, were not the person concerned.
Lord,
That is
This
the
is
whole.
the records,
Page 264.
264, my lord. It is, I think, my lord, volume 2, my lord.
Yes. Certified copy of the provisional certificate of diploma.
Admission bearing number 393, certificate copy of provisional certificate of diploma, certificate copy of the letter dated 12/10, wherein the principal specifically stated that K. Amos was not enrolled in the institution during the year 1986-87 for diploma engineering, and the certificate is fake.
My lord, that diploma certificate, furthermore, the important aspect is, was not, my lord, a criteria for the purpose of getting.
That is
employment.
different. That
Lord,
is
that-
different, but your integrity.
Yes.
What is important is your integrity.
Lord, the question is, he all along participated in the proceedings. He have cross-examined all the
No,
witnesses.
no.
This is an inquiry, my lord, we
Yes.
kindly see.
I-
He
I-
ju-
I- I
my lord, he
can see-
abandoned the
Yeah.
proceedings. He abandoned the proceedings because not a
No.
suspension officer has to be stayed in the quarter, which has been already there, last address. He abandoned, he has, after filing an application saying that the proceeding initiated by the inquiry authority is biased.
I am showing.
Thereafter, he abandoned the proceedings.
No, I have not abandoned.
When opportunity was given him to.
Two articles of charge.
Yes, my lord.
One is the date of
A
birth.
date of birth, one is a
and
fake
the
certificate. The
certificate.
Both the charges has been proved.
How can you prove the date of birth to be wrong?
My lord, the date of birth he has initially is as 1960. Primary school when he has studied, the transfer certificate is given 1960. When he has failed in 9th, subsequently he joined in another school
That you
by
said.
manipulating, saying that my date of birth is 4/12/1967.
Yes.
Then he passed in 10th, that is CBSE as their contention. My lord, the principal of
Did
the.
did you contact the CBSE board
My lord,
to
both the
inquire whether?
principals have been called for as a
Not the
witness.
principals, the
CBSE.
CBSE.
Lord, the 9th certificate, the date of birth is an issue. The date of birth in the CBSE is not an issue. Lord, he has joined a primary school with a date of birth of 1960.
When there are two contradictory documents, the primary one and the class 10 board, which is to be taken into consideration?
Lord, I understand. The
What you understand?
Lord,
No,
Lord,
no, you please say what you
Lord,
understand.
because-
We are not understanding
sorry.
what you are understanding.
Lord, I'm sorry, Lord. I mean to say, my Lord, if you are saying that I am studying at 9th standard, there should be a date of birth which is be prevailing in your primary school education. The primary school education, he has given a date of birth of 1960.
How can a person know his date of birth when he was born? Whatever he has heard from the
Lord-
parents, whatever the parents, right, he is
It-
going to accept
In
that.
the ninth standard, when he has submitted the date of birth, because he has joined in some other school.
The parents have taken the child to some other school because the child is a minor
Right,
at
my
that
lord.
point of time.
When he has been on ninth standard, when he has joined, he has made a date of birth of 4/12/1967.
Yes,
Based on that date of birth certificate, he has been went to the
Joint service.
CBSE.
right.
Now he produced the certificate of CBSE. Now his initial date of birth with regard to that school joining.
Show us decisions in this
My
regard.
lord, if it could have been that the without taking consideration into the primary documents, the secondary will take into place, then the question will rise. But the inquiry authorities have called the principals of both the schools.
Could the inquiry officer gone to this extent?
My lord, because
What
they
is
are the
the
person who
position
are the
of
author
law?
of the document. They have come.
Doesn't matter what is the position of law. If there is a school leaving certificate of a primary school and you have the board certificate, which one is to be taken into consideration? Please show us the
Not the
point of
school
law.
leaving certificate, the board is come to be as a subsequent event, not because the primary.
What's the provision of law?
No,
which
I will
you-
bring it
which
tomorrow.
show-
I will bring it
what is
tomorrow.
the judgment that is to be,
Yes.
what is the
Monday.
law that is to be taken into
Yes,
consideration?
I'm showing, my lord. My lord, I'll be referring, my lord, the copy.
Please show.
But only one thing, one judgment I have not written over here. I shall, my lord, hand over it, my lord, and kindly take a note on procedural delay. And this is a short written note, my lord.
Procedural delay will
No,
see
procedural
differ.
irregularity.
Irregularity is different. You show us as regards the date of birth,
Yes,
what
yes.
should be the
Judgment, your lordship will
Mhm.
kindly come to, yes, yes. My lord, then, my lord, kindly come to volume 6. My lord, kindly come to page. My lord, 879 at volume 6. I'll show, my lord, only one paragraph, last paragraph.
yes, 879?
Yes, my lord. Your lordship will kindly come to paragraph 30 at page 897.
So volume 6.
Paragraph
30, 30.
30.
879.
879, 897, 897.
897.
Yes.
Well, may I read for my lords? The law is well settled that the determination of the question as to the correct age of a person would depend largely on documents and the nature of their authenticity. Amongst the documents which have been accepted in proof of age is the admission form to a school, which is a part of record maintained in the ordinary course of a business and signed by the parents and countersigned by the headmistress, and which is otherwise authentic and unimpeachable. The reason for acceptance of such evidence is that there would be no dispute about the date of birth. There could be no motive on the part of the parents to give a false date of birth at the time of first admission to school at the very early age. Refer judgment, the judgment has been referred. The matriculation certificate recording the date of birth has also been regarded as authentic and accepted in support of proof of age. If the genuineness is not in doubt, but the question of correction of birth date in the service record of government servant arose in cases before this court, then another judgment has been referred. And my lord, there and Sishuranjan Das versus Commissioner of Police 79 to CLJ, my lord, in a former case, it was observed that when the original matriculation certificate is produced before us and no reply is possible in the facts of the case, we have no hesitation to accept the case of the petitioner appellant that his date of birth as stated in the matriculation certificate must be accepted. In the latter case, it was observed if the verification of date of birth is not made in terms of the procedure laid down in the relevant rules, the entry made in the service roll cannot be regarded as a valid declaration. So, my lord, the print and substance is, my lord, if it is there, it was not doubted, kindly see, my lord, at the time of making an application, I produced the CBSE certificate. I give all my testimonials. They, my lord, verified the documents. They made scrutiny. I was found eligible to appear at the interview. Only then I was given, and in my service record, my lord, it has been recorded as 1967. There is no dispute. For long 31 years, there was no dispute. Again, 31, my lord, the Honorable Court observed, my lord, can you see, the bank erred in not recording the date of birth as matriculation certificate because there was a discrepancy in the service record.
This vacancy, this person, received this CBSE authority and for us.
Matriculation certificate.
That misled them and you obtained the certificate. This is the reason. So they have not misled him.
What would be your decisions in this regard?
30 suppose, rather if 30 says, the initial birth given by the parents should not be treated to be as a fake.
Just kindly give me leave for 1 minute. Just coming from outside.
Lord, the question is, Lord, if a person is giving a date of birth certificate for attaining a job, and that to be a period of 7 years, because as per the job, if he intend to be obtained, he is required to have a 25 years of age.
It comes later on
Yeah.
job, but then suppose a candidate who is aged 26 years
Yes, ma'am.
sits for an examination, which is
Class
for
10.
class 10, 16 years,
26 years.
right?
School.
Imagine the difference. At when he gets the job, you will not be able to ascertain his age by seeing his face. But a student of class 10, whether he is 16 years or 26 years, can be easily ascertained. The school permitted the child to be admitted.
In 9.
The school, it was a regular school. It's not that open board examination.
Yes, because that's why the headmasters, it is not issued by him.
What
But
is not issued by him?
as the 9th certificate he is producing, that was issued not by the concerned school.
No, I
Not the
see.
charge.
But then the next school which admitted the
That
student,
is, Lord, that is why I'm saying, Lord, a transfer, Lordship is saying that the 9th certificate, he got a transfer certificate, he admitted in the 9th, in some other school.
other school. Now,
Yes.
other
Now
school
the-
never raised an issue.
That is Lord, the 9th certificate based on the transfer certificate when he has means admitted in the some other school. That saying, I have not issued that transfer certificate
And this came to your knowledge only after
after the complaints and the
it was your
investigation.
duty when you appoint a person to go for a police verification.
Lord,
the
police
PVR
verification
is
regard
done.
to character antecedent, the police verification would be.
No, not only character antecedent, the date of birth, the documents relied upon,
Lord,
everything
because
is
he has
checked.
been produced the date of birth of the CBSE,
You accepted it,
accepted,
right?
yes.
Fake certificate diploma is something different. We'll see to that. But as regards the date of birth,
Lord,
can
CBSE certificate is not fake.
Lord,
no, certificate is not fake.
He has appeared,
CBSE
he has passed also.
when he joined under the class 9 based on a transfer certificate, that is fake.
But you see,
So what-
26 years boy will appear.
No, I will also search more. I will bring citations for as Lordship is saying, because a certificate, as Lordship is saying, the declaration done by the parents, so that whether that will be treated to be as a date of birth or a declaration done by the appellant here in being a government servant before the joining of the department, that to be taken into consideration.
No, because the date of birth, what is there in the matriculation certificate is the same
Yes, my lord.
as he has given. He has not, as to this date of birth, in connection with the CBSE certificate and service records are at par. You cannot say that he
No,
has given
Lordship
a
is right.
false
Even I
date of
cannot
birth.
deny that to that extent. Lordship is right. Because the CBSE certificate, the date of birth, and after based on the date of birth, he has joined. That is
What
not.
is your submission is that the recording in the CBSE certificate is also
No, not the
fake.
recording. No, I'm saying the recording of the date of birth, which is in class 9.
Oh, that has
That
been
is
down
been
to
subsequently
CBSE.
when he cleared class 9, he 10 to 10.
See, in
Right,
all
can
boards,
you
there
do
is a
that?
Not
In all
because
groups,
it
there
is-
is a provision, you see, CBSE, ICC, everywhere, that with regard to date of birth, at the time of filling up the forms for the final examination, they can make necessary rectification. Because once it is entered, hardly there is any scope.
It
So
is
that
final.
scope is
Lord,
there.
that is why I'm saying, Lord, when a date of birth, which is he has been, the trans.
So why do you think that to be sacrosanct?
If at all he going to be admitted in class 9 based on a certain transfer certificate, when that transfer certificate itself is not issued by the concerned school,
Can you raise this issue now is the question.
Lord, it can be, Lord, because
Show me that provision of
just
law.
not today, but Monday I will show it.
This is the main
Yes.
question with regard to the date of birth.
Lordship want to know whether at this stage that issues can be raised or not.
When you yourself could not find out this issue, it was on a complaint based by some private parties that issue has come up. Show us that provision
Yes,
of
sir.
law that you can go into it at this stage.
Yes.
Because all along, the decisions, the line of decisions is that the CBSE certificate or the class 10 board certificate is taken to be authentic as regards the date of birth is concerned. This is the steady view of the courts. Now, your submission is that, no, that was also wrong.
Because the date of, for attaining a government job.
Don't go to the job. Job
Lord, because
comes
if he's-
later.
Yes. My lord want to know whether that CBSE certificate which is issued by the board will be considered to be
Authentic
authentic or not,
document
or
for
the declaration
recording
which is
the
done by
date
the
of birth.
parents prior to his admission,
Yes.
that will be declared to be as authentic or not.
Right.
Well, let me I produce it tomorrow, Monday morning.
You take some more time. Monday, I do not think you'll be able to do it.
But it will fix in Wednesday,
And
my
then
lord, because
it's,
Tuesday.
I said online, but day on which fix my leaving aside all other. I said,
Wednesday it will be fixed. my lord.
Because that day, the court permitted you to join online. You were not required to come all the way over here.
My lord permitted, but thing is, my lord, the difficulty which was I could not hear anything. I could not hear anything there because of the weather.
No, that is,
But
you
that is-
never know. It can happen anytime.
No, yes, my lord. No, hopefully, my lord.
Even here, when they are submitting and it's raining,
We
we
cannot hear.
fail to hear properly.
Yes. But only one liberty, my lord, kindly be granted. The some other judgments were they are referred, they are two, my lord. In the written notes on argument, I have, my lord, we find that I have analyzed everything. I shall, my lord, rest my arguments on that, from online, I will do that. Only the copy of the judgments I have
No,
brought.
no, that you can give anytime. No issues with regard to that.
Yes, but I am giving those judgments to my lord. My lord will take the trouble, and on that day I shall, my lord, referring the paragraphs, I have referred the paragraph in the written notes also, which I have handed over. The only judgment, my lord, which I could not record there, I am giving, my lord, my written notes, my lord, even to my learned friend. So that he can come back. Judgment you.
What about the fake certificate? The, what will be your submission with regard to the fake certificate? The Polytechnic.
I never used it as a tool of my promotion. Subsequently, which I.
Whether the certificate is fake or not, what is your submission?
But because according to me, my
How
lord,
could the certificate come into existence if you never used it?
So why have you relied on it?
Why have you relied?
no, I have not relied upon, but that's why I am submitting. I have not relied upon.
No,
Where
at the
from
time of
this,
your application.
No, at the time
Where
of
from did
employment.
the authority get
Well, at
the?
the time of employment, that certificate
Was not produced before the authority.
not used before the authority.
How
Only
did the
from-
certificate come?
No, it's a
Existence.
subsequent
Authority then.
event, my lord. According to the authority, my lord, it is a subsequent event. And my lord, the
Subsequent event means you procured that certificate?
and that I shall take instruction. I shall
Obviously, that is the case.
No, that is the case, but that my lord, fact remains. Fact remains, your lordship can be appreciate that whether that can be a subject matter when a document, if it was there.
it has been procured by the respondents. Because it is not that I submitted before the school respondent authority.
You never submitted.
No,
They
it-
found it out.
no, they found it is from the police itself.
From some other person's complaint.
How did you please get to know?
But I-
Somebody must have complained.
That I can
Not Pandit's
explain, my
complaint.
lord,
Ah,
because I didn't anticipate.
So whether
no
that is,
third party
whether that is a
get it.
misconduct or not, that is the thing.
Yeah.
You are using some fake things outside, whether that
Yes,
is a
yes.
misconduct.
Yes, my lord, your lordship will kindly consider, because that I have also taken a note point to that effect. Because the charge is, your lordship kindly see, we are traveling with the charge of forgery. Whether that can be treated to be a forgery if I have not used, because the subsequent promotion. which-
Forgery in the course of your service,
Yes,
in the course of employment.
yes, in the forgery of, if a document, my lord knows man better than me, insofar as IPCs, old IPCs and present, my lord, BNS is concerned. If a document is there, if it is not used for the purpose of any benefit, say suppose, my lord, it was my desire, my dream, I have prepared a document that I am such and such, such and such.
Sir, this is
Had
not
I-
allowed.
If I not use, man, I'm coming, man, I'm explaining. If I not use, my lord, suppose I'm submitting. Your lordship, can you see another example? But I have dressed myself like a king, or like, my lord, the prime minister. I have prepared a photograph of mine. I have kept in my house. Hypothetically, if I have not used that photograph or the document in any manner whatsoever for the purpose of fetching any benefit, can I be charged with forgery? When it was not with the authorities' record that I have submitted that.
They have relied upon that
They have
document.
relied upon from the basis of the, my lord,
Complaint.
documents, my lord, by the police authority. They are there. You will also kindly appreciate this, because my lord, I have gone through a judgment to that aspect. My lord, when I submit, at least I know, my lord, at this age, if I submit anything which would be rubbish, but I feel ashamed for that. But this is the correct legal proposition. Possibly, my lord, the name of the judgment is Fazela Khatun, or like this, my lord. The judgment was delivered by my lord Justice Torun Chatterjee while he was in Supreme. I have gone through that. That's why I am submitting. Right now, I can't.
but then your integrity will certainly
No,
be
no,
a question mark.
integrity, my lord, how a question of integrity, does it have any connection with my employment?
Certainly.
No,
What
no,
you
no,
say?
no, no. Your lordship-
Integrity
your lordship-
not in
no,
connection with
your
your
lordship-
employment.
No, your lordship, kindly
Maybe it
appreciate.
is in the, with regard to third party, okay, assuming. It is
Mm.
not with regard to the employer-employee, it is with regard to a third party. You have cheated somebody else, but whether that is a misconduct as per
Right,
the
if I
regulation.
have cheated at all anybody.
Cheated Mr. X or Y,
Yes. if
whether
I
it is
cheated,
a
if I
misconduct.
said any Tom Dick, and only then, my lord, is the question, my lord, the moment I have the question of coming cheating comes, then, my lord, the necessary question drops up that I have gained some benefit by cheating. If I have not gained any benefit on the basis of that, because the certificate, my lord, we find on the basis of which I got promoted is that ICVT certificate, vocational training certificate. That was the basic, fundamental basis for giving me promotion as judgment.
An article of charge has been framed, served
Mm.
to him. He
Mm.
could have defended, saying that this has been done, this is
Nothing
not
done,
fair.
because
He is accepting that
because
position.
the inquiry officer.
Not, it is beyond not his
inquiry
fact that
officer
anything has been
was
done.
My lord, yes, man of the chief engineer. He has to appease his boss anyhow.
No, he has
Now-
not questioned, my lord.
yes.
He has all along.
None of my
participated in
submissions were
proceedings. I'm
recorded
showing
and adhered to
records.
was considered.
He cross-examined all the witnesses.
no.
And his turn.
I'm very sorry, I'm very sorry, my landed is not making the correct.
Anyway, report will speak for
Yes,
itself.
yes, yes.
Yes.
The entire report
But
as well as the evidence.
I shall, I have.
Everything
given, my
is
lord.
on record.
I have given, it is my categorical from the inquiry reports, order sheets I have info, disclosed. Therefrom it is, my lord, will find that my prayer was rejected. I called, my lord, the defense witnesses, including those principals who made those submissions. That is of, my lord, diploma, as well as that, my lord, another organization. Because the persons who deposed, they were not the author of the document. And my lord, it is, my lord, list to argue that if any document has to be testified or proved, the author of the document has to be testified. The author of the document has to be examined. The document is not sacrosanct, my lord, in the, under the Indian Evidence Act also, my lord, will apply.
It's absolutely right. That this person was having the knowledge that he was in possession of a fortune.
এই judgment গুলো set গুলো করো না, একটা একটা করে সাজিয়ে দিতে হবে।
Safe.
একটা একটা করে
Yeah, right.
সাজিয়ে দাও যতগুলো আছে।
The post of a tenant for him.
ওটা দিয়ে দেবে তো?
Let's say big.
Yes, use that in the interview. So how we can defend it.
Very well, please come.
My lord, only one thing, my lord, you'll also kindly permit me, other judgments, and my learned friend will hand over that, which I have relied upon. This judgment is not with them, my lord, I have forgotten to enclose this. This is 1998, volume 7 SCC.
You take this back, stitch it and then give it, no issues. This,
Other judgments are there, my lord. 18 judgments I have referred there to.
all right.
This is number 19.
All right, you just stitch this up, then it will be easy. এটা দিয়ে দিন, এখান থেকে ওনারটা দিয়ে
এখানেও
দিন।
এর মধ্যে আছে।
Well, you can stitch it up so that it can stay together. It will be easy. Just now you can stitch and hand it over.
এই দুটো একটু লাগে।
Heard submission made by the learned advocate for the petitioner. Stop. List the matter for further hearing on Tuesday, we keep it.
Yes.
1st of September.
এগুলো সময় লাগিয়ে রাখছে। My lord,
Yes, yes, no issues.
I'll give you, like,
Oh, Blair.
bring it present. Right, I'll give you.
All right. There is a Passover matter. Yes, please call.
আচ্ছা।
There is a Passover matter.
I am appealing for the appellant.
Can this matter be sent for mediation? It can.
So let it go to mediation.
It appears from the submissions made on behalf of both the parties. Is there any official respondent over here?
Municipal council I am appearing.
Municipal
They
council,
have made a.
private parties. Private parties. That there is a scope for settlement of the dispute in question. Stop. In view of the above, the court inclines to avail the remedy of mediation for settlement of the dispute. Stop. Do you all have a list of mediators?
Yes, yes.
All right,
6.
right. Maybe, does he appoint or does the court appoint? Member secretary, all right, then whatever the regular order is, it please. And in case the mediation fails, then it comes back. Is it also recorded in the order?
Both of the mediator after 5 weeks or 6 weeks.
Yes, the mediator will file a report before this court. What is the usual time given? 4 weeks? 4
4 weeks is not required, my lord.
15 days or 2 weeks.
15, 20 days it's more.
4 weeks it had, 4 weeks ago, because the next available.
Yes. We are giving 4 weeks liberty to mention in case if the mediation proceeding becomes successful, please
My lord,
mention and you
My
can
lord,
get
my-
it done.
my lord.
All right.
Liberty to mention will remain. Sure.
My lord, item number 28 and 29, my lord. It's with regard to appointment in police department, my lord. My lord,
28 and 29.
it's a writ petition,
Yes.
WPCT, my lord.
Yes.
Here, the matter was taken up on 28th of July. When, my lord, despite of the fact that all the documents are available, the other side sought time to file affidavit within 2 weeks. Now, my lord, it's more than a month.
Not filed.
Not filed, and
Who
there,
is the other side?
my lord, Mr. Debu Chaudhary is appearing. I
Where is
have sent a mail to him yesterday itself that I will mention this matter.
Then Monday, please put it under the heading to be mentioned,
My lord.
28 and
My lord,
29.
and they are pursuing merrily with the selection process. So I will
Alright.
be-
There is
All
no
right.
interim of protection.
No, I have prayed for, but at that junction, it was not, so I.
Required also. Very well, 28 and 29 to be mentioned on Monday.
I'm ready.
And please give notice to Mr.
Yes,
Chaudhary.
my lord, once again, I will.
Yes.
All right. Why don't you all get pay slips? It must be mentioned over there, reduce. Reason is not mentioned, so you don't say that you got to know from the ITR. You should have checked up your receipts. Audit report, I get it. All right. Why do we mention Mr. Rakesh Kumar? Is he here? Tuesday. This is under heading hearing. It's a hearing matter, isn't it? All right. It will be there as the first matter in the hearing list. First matter in the hearing list, please intimate your other side. Mr. Rakesh Kumar should be intimated. All right. Tuesday. Yesterday, this matter was
Yes, madam.
concluded hearing. I just
Madam.
wanted to check out whether the documents which you relied upon was placed before the learned labor court, but then I found that it was not there. It is only the court has recorded that only one witness of the
Yes, madam. Two documents
first
were
party
exhibited.
was there and only two exhibits and this. All right, so whatever the order remains yesterday will remain.
Madam.
No order. Yesterday's order will remain. Short passover. Who is your other side? Your other side? Miss Babita Das? Item 2?
Official respondent.
Yes. There are private respondents also.
Yes, my lord. One.
Who are they?
Number 1.
Right, I can see. Where is the private respondent?
I'm praying for a short pass, which is the English team number 1.
But you said you prayed on behalf of the petitioner. I understand. Who is for the private respondent? Has it been served? Please check up whether it has been served or not.
Been served, your lordship.
Nobody is appearing.
Respondent number 1 is the mother, my lord.
Service is
She
not
is the
here.
mother, and her complaint, on the basis of her complaint, being a senior citizen.
Under the Senior Citizens
Yes,
Act.
my lord.
Where is the service upon the private respondent?
Affidavit of service, my lord.
Please show it to us. Please check whether it has been served. Vidya Singh. No, there is no postal track report. Where is the postal track report?
I'm praying for a short pass.
All right, pass over.
It's the report is also attached.
That is the postal receipt. That is
Delivery
not
report.
the track report.
Delivery details.
And Pradeep? Has it been served? The respondents, nobody is here? None appears on behalf of either of the parties at the time of call. List the matter on Tuesday, 1st September. Item 4, same order as 3.
I'm praying for till Thursday, my lord. Service is not affected, my lord, upon all the respondents.
Learned advocate for the petitioner submits that service upon the respondents have not been affected. Stop.
Thursday.
List the matter on Thursday, 6th
No, it's 3rd September. Service in the meantime.
Okay. My lord, I am for the respondent.
This is item 6 possibly. Item. Item 6, yes.
In this matter, Mr. Vijay Kumar is appearing. I am in proxy counsel and pay for this matter may be fixed on the next week.
Wednesday.
Yes, Your Lordship.
Why?
Your Lordship, the senior is not in the town.
Maybe. Then you should try to proceed. Otherwise, if all matters are fixed next week, when will the hearing be taken place?
Should they like both the matter to make it?
6 and 7, what is your submission?
Because one RC proceeding is going on, my lord, for subdivision
Right,
before the deputy commissioner.
that can be
And notices
concluded.
were issued on various dates. I don't know, all the parties may not have appeared before her, before the deputy commissioner, so it could not be proceeded. If my lord sees page number 53, the last.
So a direction can be passed for conclusion of the proceeding.
My lord, upon hearing all the adjacent
Necessary
plot
part.
holders also, because because only one writ petitioner has come, but there are
As
other-
prayed for by the learned counsel
Correct.
for the petitioner, comma, list the matter on 2nd September.
And then, my lord,
6 and 7 both.
mine.
Lordship, generally I used to appear on behalf of the respondent authority. Whether he has served or not, Lordship, I do not know because I have not received any instruction from the department.
Difficulty is the petitioner is also
I
not.
am appealing to the
So,
Lordship.
that will be adjourned. None appears on behalf of the petitioner. Stop, list the matter on Tuesday. Stop,
Lordship.
suppress in the meantime, if not already
Yes.
served earlier.
Lordship. Deeply obliged, Lordship.
Lord, I am for respond number 1 and 2, my lord.
Especially pertaining to the government footpath being enforced by the.
Yes.
Even yesterday also.
Right. Respondent number 3 is present. Yesterday, accommodation was sought for on behalf of the respondent number 3. And today nobody is here. What is your submission?
My lord, because they have submitted one order, stay order, for that reason, we present up, otherwise, my lord, pass the direction for
Yes,
this eviction order, which is page number 21. to
21.
execute the eviction order, my lord, within a time frame.
Yes,
It's page 21.
right. None appears on behalf of the respondent number 3. Stop. Learned advocate for the petitioner. Not learned advocate. The petitioner prays for execution of the order passed under section 104 of A and N Islands, comma, L and LRR 1966, dated 9th April
No, my lord. That's it.
2026. Stop. It appears that direction has been passed to vacate the unauthorized occupation of the government footpath bearing survey number 6. Stop paragraph. As the government footpath is primarily meant for use by the pedestrians, comma, the same ought not to be occupied by any private party. Stop. The Tehsildar, comma, respondent number 2 is directed to take steps for proceeding with the execution of the subject order. Stop. Let a report by the Tehsildar be placed before this court on 4th September. The progress of the execution of the said order shall be disclosed.
Is there any requirement for directing the police to be present there?
If it is required, because
Last location of the safety.
Yes.
if the Tehsildar requires, my lord,
It will be open for this Tehsildar to seek for necessary police assistance for the purpose of executing the subject
Right.
order.
obliged.
I pay for respondents.
Where is the petitioner? What to do?
Today being a resolution not to.
Oh, there is a resolution, right. None appears for the petitioners. Stop. List the matter next Tuesday.
Obliged, my lord.
Senior appears on behalf of the petitioner, your lordship, praying for not to.
I pay for official response.
And for the computers.
Only not today.
Only not to do.
All right, not today.
I'm responding, official response.
Petitioner is not here? Not today.
My lord, I am appealing for the petitioner.
Yes, please.
Official response.
Actually, my lord, one of the private respondents succumbed to death, my lord. My learned friend was directed to supply the address of the
Details.
so that I can pursue further. But that is going on from last several dates, my lord, when the private respondent.
Who is appearing?
Mr. Jayapal is up.
All right, today is not here, then next day.
I'm for the petitioner.
Mr.
Mr.
Rakesh Kumar, he was here. Where did he go?
He's here, my lord, he's doing item number 4.
Oh, in the other bench. Let it be passed over.
I am appearing for the respondents, my lord.
Not today.
Obliged.
My lord, I am appealing for my lord. Here they have filed an report, and last occasion when the matter was taken up, the court was not convinced with the report and directed them to file an opposition within a period of 1 week. Mandatory order was passed, my lord.
Right.
But that also expired, my lord. So Mr. Rakesh comes, my lord. अभी डायरेक्ट करता सब पे चेंज नहीं
Mr. Kumar is not here.
मतलब पास
So pass it over.
I pay for respondent.
Petitioner is not here. Not today.
Obliged.
Manoj Paul is online.
Madam,
Is it audible, ma'am?
Yes.
Ma'am, actually, I have submitted an additional application seeking addition of party to Google LLC, ma'am. So I have to submit affidavit in opposition before it. I have already sent the copy of the petition to them via mail.
Yes. Nobody is appearing today, all right? So I will just adjourn it for the day. Next day, let's see what happens.
Okay, ma'am. Thank you.
Not today.
My lord, this matter, my lord, this is with regard to GST, my lord.
Hmm.
My lord, some Calcutta-based lawyer is opposing this application, my lord. I don't know who is appearing in this matter. His name is there.
You will get the phone number of the learned counsel and you can contact. Or you can send some communication.
Yes, my lord, one number is there. One number is there.
All
I will send the mail, let it be, because here my very ground is that violation of principle of natural justice. So I want the matter may be relegated. I will serve and come back, my lord, Monday.
Monday, not today.
Monday. Lord, I am appearing for the petitioner. Say here.
I am waiting for the respondent.
All the respondents, is there any other respondent?
Yes,
There
my
are
lord.
several advocates appearing.
Several. I
Yes,
can see the names.
yes,
Many are not here today. In that case, not today.
my lord.
Obliged.
Please intimate the other side, whoever is there, so that they can at
Yes,
least.
my lord. Here also, my lord, I am just praying for disposal of the representative.
All right.
No, I'm appearing on behalf of Tapan sir. He is not well today. So he pray for adjournment today and for that the matter be taken up in any day next week. Ma'am.
Only not today.
Not today. Thank you.
22, just not today, my lord.
All right, not today.
My lord, this may be taken up, my lord, because in this matter, there were two issues, my lord. The matter traveled up to Supreme Court. My lord, two issues were the benefit of 1/30th of pay plus DNS allowances and regularization. Both were given in terms of both were given from a subsequent date. So firstly, I taken out an application with regard to the benefit of 1/30th of pay from the date of initial engagement. That matter came up before my lord in the earlier proceeding, my lord, and my lord has passed an order. If my lord sees that order, because all the facts are there, facts would not be any departure from that, my lord. Only I have to satisfy that they are entitled from the initial date. Now, if my lord sees my lord's judgment, it starts from page 84, 10th December 2024. This they carried in an appeal. Appeal was dismissed. They have complied the order.
Page 84.
84 of the writ petition, my lord.
No, not this. Then Chidambaram.
No, my lord. This is 23, my lord.
23.
I'm sorry.
Hmm.
22, I'm not fully.
The name appeared to be very familiar, so I was wondering whether I had taken up this
Yes,
matter
yes, my
or
lord.
not.
Full-fledged hearing was taken place.
Yes.
My lord has even accorded interest also. They have challenged it, and thereafter it was dismissed. Only the time was extended.
84. Yes.
Here, all the facts were recorded, my lord. There were two
Alright.
parts. In this writ petition, I have sought for antedating the benefit of 1/30th. That was allowed. Now, my lord, I filed this writ petition with regard to the regularization which was given to them in terms of the order of Uma Devi from a subsequent date that was accorded from 2015. So I pray that that ought to be from the date of my initial engagement, or at least from 2006 when the judgment of Uma Devi came. It can't be under no stretch of imagination. It can't be from 2015.
Is anything mentioned in the order as to when from when it has to be given? There is directed to release the area dues of the workers strictly in accordance with the award passed by the tribunal.
Award says from the date of initial engagement, my lord. That award is also enclosed.
Award.
I'm just placing. Award I will place, my lord.
Now, if this order is affirmed,
My
that
lord.
means the
They have
data,
made the
the
payment also.
award also gets
Everything
affirmed.
affirmed, my lord.
And then how could the date be later on? It has to be
It ought
from
to
the
be, my
date
lord. Yes,
of
they have
the
given
award.
it from subsequent date. That order I have enclosed. So in this, my lord, everything has been stated. So there, the regularization was not an issue, therefore I have not prayed. Then I filed a writ petition. For regularization also, my lord, despite of the order of the Honorable Supreme Court, I have to file a writ petition. Thereafter, they filed an appeal. Thereafter, they filed an SLP. Thereafter, I filed a contempt application. In contempt, they have complied the order from a subsequent date. The court said, you are at liberty to challenge it if you are aggrieved by that in contempt. And then this writ petition was taken up. Now, my lord may kindly see the date, my lord, since when they were given.
So here you are not praying for regularization?
Here already they have been regularized from a subsequent
Regularized.
date.
This
I-
date you want?
Yes, yes, my lord. That is only the issue. If my lord sees page 64.
Let your other side.
Yes, yes, my lord. Let him come.
I pass it over.
My lord. Here I am appearing for the petitioner, my lord.
I am appearing for respondent 2 and 5, my lord.
There are others also.
Yes,
You
Yes,
can
just
see.
not today, my lord.
Not today. 25, 26, 27, all not today because the petitioner is not here. Similar matters, isn't it? It can be disposed of or it is to be heard. So it has to be heard. Not today.
I appear for the respondent, my lord. This can be,
Is there any other party?
no, it can be not today, my lord.
Not today.
Not today.
Is there any other party who's
no
not
other
appearing?
party. No. No other.
Both of y'all are here, even then
Yes.
not today. Why?
Let it be
Not-
taken. Let it be taken. No issue.
Let it be taken up now or on Monday?
No.
Oh, then it's all right. 28.
Your Lordship, I have challenged the order passed by the Revenue Secretary, which is at page number 84, Your Lordship. I'm sorry. not 84.
Page 112.
I have some difficulty, I think. Defense and not free. Yes, one of the Your Lordship. This is the order which has been passed by the Revenue Secretary. Your Lordship. Now,
2 years delay.
Yes, but delay has been condoned. Delay was condoned. Second line, appellant is filed after a lapse of 2 years, delay condoned in the interest of justice. Delay was condoned. The appellant was provided an opportunity of hearing on 4/1/2024. However, the appellant failed to produce any documents to prove that Valiant and Chopin is one and the same person. Now, Your Lordship, this honorable court, possibly in the last decision, Your Lordship asked me to file one affidavit. And it was filed also, Your Lordship.
You were supposed to file an affidavit.
Yes, Your Lordship, because the court has said that, I think.
It is all along, I see the affidavit of the respondents.
1 minute, Your Lordship. Excuse me.
Yes.
थोड़ा फाइल देखें सर ये फाइल में देखिए इस फाइल ये फाइल है ना ये केस का फाइल टोटल
No, there is no affidavit. Oh, supplementary affidavit, all right, yes. On behalf of the petitioner. Affidavit in opposition on behalf of the respondent, reply on behalf of to the affidavit in opposition. Supplementary affidavit, has it been served upon you?
Yes, my lord, I have received it.
They have not found any reply to that. The reason is that, my lordship, the revenue secretary has said that I have to prove Belayan and Kottayan are at least one and the same person. That is not my case at all.
Our stand in the speaking order, my lord, it is
No,
clear.
wait,
All
wait a
right,
minute,
wait. Yes.
All in all, my case is that they are two different persons, but in the case of the name of Belayan, Kottayan name was insulted.
Wrongly inserted.
Wrongly inserted. It was never my case that both are same and one person.
Show.
So this honorable court on the last occasion asked me to file a supplementary affidavit. I filed a supplementary affidavit, and in the supplementary affidavit, I have specifically mentioned on affidavit. Kindly come to page number 40.
Yes.
The court has asked me that you search out the children or the legal heirs of Kottayan. Kottayan also died. And ask them to file an affidavit stating that they do not have any claim in respect of this land.
And you managed to do that?
I asked them, they have said yes, because they are not in possession. They are having no right in respect of the property. They say that means it was by mistake the name has been written. So they also know about it. So I have requested them, they filed the affidavit. Page number 14 is the affidavit filed by them. He is the wife and the son. Both of them have filed the affidavit.
Is this person, the heir, the widow, has filed an affidavit? Why don't you make the widow a party? Or let us see what is the case that you made out before the authority.
Yes, sir.
What exactly was your prayer?
My first representation will clear the fact. This, your lordship, may kindly come to page number 27.
Yes.
I have already submitted, your lordship, about the story with regard to the right of the father, my father, because he is.
Are they brothers or anything related to each other? Nothing.
No.
Neighbors, nothing.
No.
Nothing.
Nothing.
How did the mistake crop up?
Even they are unable to find out who is Kottayan. Let them tell who is Kottayan. I will not have any claim over that land. Because time and again, this honorable court has also asked them that at least you produce. You have recorded the name of one person in your records. And you also don't know who is that person. Now, I have stated from paragraph 6, page number 28, that while conducting inquiry for village Indranagar, which falls within the Paragraph session, the High Power Committee might be inadvertently and due to sheer oversight did not propose the name of my late father for having regularization of the said land under the said seal. Since my father was an illiterate, he was not having any knowledge about the impact of his name being excluded for being considered for regularization of the above mentioned land. Since I was away from these islands and serving for the nation during those periods when the High Power Committee conducted its inquiry at village Indranagar, and as such, I had no occasion to put forth my claim on behalf of my father for regularization. The applicant was studied up to first 8th to 11th standard in Andaman Nicobar Islands, namely Banglutan Middle School, government spaces, and senior applicant had joined Indian Air Force and was transferred to various parts of this country to serve for nation and completed 20 years of service. After retirement, your applicant was staying in the Air Force training house, which is standing in the enclosed lands. Total period of stay except the aforementioned landed property, the applicant is not having any piece of land in these islands till date. The adjacent plot to enclose the part of survey number this to the tune of 1 hectare was extended to the benefit as the revenue officer issued license in their name to occupy the said land. Photostat copy of license dated in the name of this and this are enclosed herewith. During my absence, the Forest Department had issued eviction notice to other who have enclosed the adjacent plot at a relevant point of time and the executive state father enclosed the aforementioned piece of land. But no eviction notice by the forest department was ever issued in favor of my late father. It seems the land is government revenue land and as the name of my late father might have been left out, now being his son who is in occupation of the said land as well as dwelling house by way present application draws your research kind attention in the aforesaid matter with a request to consider the case for regularization of the said piece of land as left out case. Similarly situated person of these islands whose case were not considered at the relevant point of time by High Power Committee as well as by the Andaman and Nicobar administration were given benefit of the scheme of regularization. Subsequently, they approached the authorities. As my case too deserved to be considered positively, the benefits so conferred upon them in the subject matter may kindly be extended in my case and necessary direction will be given to the subordinate revenue officer to do all this. This was my case in the beginning. Now, Your Lordship, when the matter was taken up, page number 30, this is a letter which has been issued by the Deputy Commissioner. I am directed to refer your petition dated this for correction of name in the encroachment list published by the Forest Department. A clarification in this matter obtained from Forest Department in which the name is mentioned as Kotel, son of Andy, at serial number 4. Just a minute. The occupied area of the applicant falls within the reserve forest block of Indranagar, which is to be allotted to the pre-78 forest encroaches, whose name published by the forest department as NC. The name of the applicant or his father's name not appeared in the list. The department has carefully examined and rejected this. Now, Your Lordship, this is the position. The forest department has recorded the name of one Kottayan, son of Andy. Andy is also my father's name.
Your father's name is also Andy. All right.
Our case is that when we came to know about this, that they have recorded the name of Kottayan, we have submitted to the authority concerned that by mistake the name of Kottayan is recorded because there is no such person called as Kottayan. First,
You do not have a brother named Kottayan because
No.
the father's name matches.
No, Your Lordship. I don't have any brother. That means my father had no brother. Now, this is the list which has been given, page number 31.
Page number 31, the actual area under possession is mentioned. At present, no encroachment is found in the locality.
Because they were not able to find Kottayan.
But then somebody else must have been there.
That they have not mentioned. My father's name was not mentioned.
Maybe. All right then.
Then thereafter, documents, just a minute. I approached this honorable court. And page number 45 is the order. The operative portion is page number 46. Since what the petitioner seeks is essentially a fact-finding exercise based on the document that the petitioner relies in support of the case, it is necessary that such action be taken by authorities. This is simply I have to make a comprehensive representation to the authorities, and the authorities were directed to consider the same after giving opportunity of hearing. Now, I submitted the representation, page number 48. All documents I have submitted.
Yeah.
And there I have specifically mentioned third line of the representation we received, page number 48. I am submitting the comprehensive application in respect of correction of our father's name, which was mistakenly recorded as Kottayan, son of late Andy, instead of Velayan, son of late Andy.
You record your father's name incorrectly, and that is the reason or mistake.
I cannot record. It was the forest department during their survey they recorded wrong name.
All right.
Now, Your Lordship, the application which was submitted at that relevant point of time by the father is at page number 50. This was an application that was also submitted. Regularization scheme was there of 1987. Your Lordship, by this time, Your Lordship knows about that scheme of 1987. So this application is there. Page number 52 is the receipt issued by the authorities.
Hmm. Is the plot number mentioned?
Encroachment land, your lordship, no
Yes.
plot number
Nothing is there.
cannot be mentioned, your lordship.
All
Because
right.
encroachment land, the
There is
party
no
concerned will be not knowing the number.
Hmm.
No, your lordship, this is the page number 53 is the order.
Yes.
Just a minute. This is the order passed by the deputy commissioner. Now, your lordship may kindly come to page number 54. The deputy commissioner relied upon the report of the assistant commissioner settlement. Now, I'm placing it. The assistant commissioner settlement based on local inquiry, field inspection, report of Tehsildar Pararganj and perusal of the concerned case, file submitted that Shri Blair and son of Andi had applied to the revenue authorities during 1988 for regularization of encroachment. Separate application was also filed by his son, Shri Murugappan. The father of the petitioners expired on 18/4/1989 as per records produced by the writ petitioners. The case of Shri Murugappan was not considered during 1989 when such cases were being considered after the last date of filing application expired on this, as it was held that the encroachment is within forest area. The case of Shri Sundaram, hearing joint writ petition with his brother Shri V.I. Yogi was rejected, holding that the encroachment was committed after 1978. The Honorable Supreme Court of India, with a order dated this, had directed to vacate the unauthorized occupation of all forest encroaches. Consequent to this, an action plan was prepared in coordination with Forest Department for shifting of pre-1978 forest encroaches in the de-reserved forest pockets and settling the identified pre-78 forest encroaches in the said de-reserved blocks in Indra Nagar de-reserved block at Manglutan. Altogether 23 forest encroaches were reported by Forest Department who were to be regularized land. That is where the regularization of the forest encroacher to the extent of land permissible under pre-72 regularization policy were to be settled without dislocation. The name of Shri Velayan Andi is not appearing in the said list. The name of one Kottayan is appearing as pre-78 encroacher in the said list provided by Forest Department with the remark that present no encroacher is found in the locality. No area under possession of Shri Kottayan could be identified. Subsequently, a survey was conducted by settlement fields of the de-reserved forest in the year 2002. During this survey and inquiry conducted by the settlement, it was reported that Kottayan son of Andi is in occupation of survey number 6 area 0.22 hectares. However, it was reported that the area is actually under occupation of Shri Kottayan son of Subhagya. He is some other person. Accordingly, cases of 17 into 378 forest encroaches, including the case of Shri Kottayan son of Subhagya, was proposed for regularization and was approved by Honorable Lieutenant Governor on 28/8/2002. Some other land, not this land. Thus, at that relevant point of time, the name of Kottayan Andi was corrected as Kottayan son of this, and the issue was settled. During the survey conducted by the settlement wing in the year 2002, as stated the serial number, Shri V. Sundaram, Shri V. Yogi, and Shri Murugappan were found to be encroaches of land within the de-reserved block to the extent of 1.10, 0.43, 1.34 hectares respectively, which is adjacent to each other and contiguous plots. During the year 2006, Shri V. Murugappan, brother of the petitioners, moved the petition stating that his name is wrongly mentioned in the pre-78 encroacher list of the block as Mariappan, whereas the name should be read as Murugappan. The case was processed in filing the Forest Department stated out of this encroaches identified by the Forest Department as 378 encroaches during 80s. The name of Shri Murugappan as a 378 is not appearing. It has been further stated that the Central Empowered Committee constituted by the Honorable Supreme Court identified 89 378 left out encroaches to be considered far with the earlier identified 1367 378 encroaches for regularization. The name of Shri Murugappan is appearing in the list of 89, which will be considered along with 88 cases, as and when Honorable Supreme Court issues directions or the recommendation of CEC. Field visit has revealed that Representative Shri Murugappan and the petitioner are living in the same contiguous area. No document could be produced by the petitioner to prove that Shri Velayan, son of Andi, and Shri Kottayan are one and the same person. The case of Shri Kottayan and Andi, son of Andi, has already been considered during the year 2002 and license has been issued by correcting the name of Shri Kottayan. This land is located at a distance from the land enclosed by the petitioners. Now, your lordship is getting it.
Yes. Paragraph 15.
Yes. But what is the relation? Because I have been saying that it was mistakenly recorded, the name of Kottayan is recorded mistakenly. Now they were able to find out that who is Kottayan. They were able to find out. And they are saying that so far as Kottayan is concerned, his real name was Kattayan. And his land has been already regularized and the land is located at a distance from the land of the petitioner. So where is the question of me proving that Velle and Kottayan are one and the same? When they themselves have found that Kottayan is a different person. His land has also been regularized and the land is located at a distance from my land. So there is no question of me proving that Kottayan and Velayan are the same on the one person. I can't prove it. And it was never my case. Well, it could be the fact that Velayan's son of auntie was residing in the same area, and obviously his three sons were also residing with him. He could have been the original encroacher. This can be assumed to the fact that all the brothers are residing in the same area in contiguous plots. Kindly see this. This has also been brought by Tehsildar Pradhan, which the petitioner has relied in support of the writ application. So a presumption is there by in the report itself that there is a possibility that Velayan was also residing along with his brothers in the same particular land. Now, Your Lordship, under the pre-78 regularization policy, a maximum of 1 hectare could be regularized in favor of one family. The CEC in its report dated this has recommended one of their brothers to be 378 left out encroacher, and the name has been recommended to be considered along with 88 others. How it is related, it is not known, Your Lordship, because this has not been relied upon by the Deputy Commissioner. This is a report. Now, this is the order. From the above submission, it will be evident that the petitioners could not produce any material to substantiate their claim, especially Velayan, son of this, and Kattayan is one and the same person. Local inquiry also should not confirm this fact. It is a fact that Sri Velayan is the father of the petitioner, so could have been the original encroacher. In that event, only his case could be considered regularization and the pre-78 regularization policy to the maximum extent of 1 hectare. However, Sri Velayan expired during 1989, that is soon after announcement of pre-78 regularization scheme. The case of Sri Velayan was apparently not considered revenue authority on this account and on account of the land being part of forest. So these are the reasons given. But Your Lordship, my application for regularization, Velayan has already given the application for regularization and receipt is also there. After the order of Honorable Supreme Court in 2002, the case of 378 forests and encroachers has been considered. However, name of the petitioner party is not appearing in this, but the name of one of his son, Sri Murugappan, has been recommended by CC for inclusion of name as 378 encroacher in addition to the list of this encroachers identified earlier by the Forest Department. Decision on this is awaited from the Honorable Apex Court as per the materials available on file and is as submitted in the proceeding. It is but logical to conclude that it is the same area which was encroached by their father. That is, they are concluding on the basis of surmises and conjecture that the land which has been proposed for Murugappan might be the same area which Velayan has encroached. But that area is completely different. I'm still in occupation. My house is there. And this Murugappan's land is different land. He is living separately from him.
But it's contagious, isn't it?
Contagious. Don't dispute to that fact.
Murugappan is your brother. Murugappan is your brother.
Murugappan
There is one more brother also, 3 of them.
Yes. 3 brothers are there.
3 brothers.
Yes.
Sundaram, Yogi and Murugappan.
Yes.
All sons of late Velayan.
Velayan.
So one has been regularized?
No, not regularized.
Murugappan?
No. It was only recommended.
Recommended. All right.
So, and that also, his recommendation, how he was recommended, whether it was recommended because Velayan was the encroacher and therefore Murugappan is in possession and as such, his name is recommended.
What is the area that he is occupying? Because the maximum extent is 1 hectare. Murugappan, how much is he occupying? And how much are you occupying?
Just a minute. As per this particular document, Murugappan is 0.43 hectares. As per this document.
0.43 hectares.
Their order.
Yes, their order it's mentioned. Sundaram is 1.10 hectares and 1.34. So if Murugappan gets more than 1.34, then you do not have a chance.
Sundaram, if Sundaram gets. Murugappan is 0.43. If Murugappan gets 0.43, then
No. Page 55, please see.
Yes.
Sundaram, Yogi and Murugappan. Sundaram is 1.10, Yogi is 0.43
This is
and
1.-
Murugappan is 1.34. So if Murugappan gets more than 1.34, you hardly get a chance.
But your lordship, there has to be a document to show that Murugappan has occupied the land on the basis of my father's occupation. If that is not there, then in that case, it can't be.
It cannot be.
Because all along, authorities have also admitted that Kottayan, maybe Kottayan or Vellayan, he was in occupation of the land in question, and thereafter I came in possession of that particular land. That is their accepted case. So how Murugappan has come, whether on the basis of Vellayan's possession or not, we don't know. Because he is my brother. And maybe initially when we all were living together, we were a family. But after that, when it was regularized or when his occupation was recognized, he had a separate family or not, that also is not reflecting from anywhere else. So in their affidavit in opposition, they have not disclosed anything of that kind. I have challenged the order from the order of the Deputy Commissioner to the Revenue Secretary's order. My main point is that it was never my case that Vellayan and Kottayan are same persons. Never. I never stated so. They are two different persons, and for Kottayan, some land has already been regularized. Then, Your Lordship,
Was this order of page 56 again challenged?
No, a review application was filed.
Before the
Same with Deputy Commissioner.
Deputy Commissioner.
Yes.
And then?
It was rejected. It was rejected, relying upon the Assistant Commissioner's report.
And then you challenge the order of review?
I approached this Honorable Court. This Honorable Court has passed an order. Page number 64. Some
Yes,
observations are
64,
there.
64.
Strangely enough, in the impugned order, the Deputy Commissioner, after recording the inclusion of the name of Murugappan as 378 encroacher in the list, further concludes that it is logical that such encroachment was made by father. The findings are mutually destructive. If the father appears to have encroached upon the land prior to 1978, one of his sons, namely Murugappan, should not have been found to have encroached prior to 1978. It is a matter of great concern that despite the specific order passed by this court, in another petition that the Deputy Commissioner consider all the documents which may be relied upon by the petitioner, has not recorded any findings on the documents produced by him. The attention of this court is drawn to emergency certificate issued on this by the Embassy of Indian Lagoon, which reveals the members of the family to be father, mother, and two minor sons. The name of other son, namely Murugappan, is absent. The said certificate further depicts the endorsement of the port registration officer Madras Harbour dated this, and an endorsement of the special Tehsildar transit camp principally, to the extent that family have been selected for settlement in Sundarapur project and the requisite allowances have been paid. Even the family identity card issued subsequently does not include the name of Murugappan as a member of the family. On the other hand, name of the petitioner is recorded therein. The learned counsels for the counsels appearing for the respective parties could not apprise the court whether the scheme has been provided a definition of the family. The conduct of the parties and the documents as indicated above would suggest that the constituent of the family were father, mother, and two minor sons, excluding the said Murugappan. The Deputy Commissioner intervened Murugappan with the family of his father and had illogically concluded that father might have enclosed the land prior to 1978, once Murugappan has been included in the list of 378 encroachers. The finding and the logic recorded in the impugned order is very hard to swallow. There is apparent inconsistency in the finding recorded in the impugned order. It also does not appear that action passed in an earlier petition was followed or adhered or by the said authority. The documents produced by the petitioners dealt herein were above the Deputy Commissioner, and it was imperative and mandatory on his part to record his finding thereupon before the proceeding to dismiss the said application. This court therefore finds the Deputy Commissioner has not complied with the order, and thereafter again it was remanded to the Deputy Commissioner. So the court has come to a definite conclusion that you cannot mix Murugappan with Vellayan and the family. This order was not challenged by them. Then
By whom?
by the authorities.
And was Murugappan a party in the writ? Never.
No, never. And
Yes.
thereafter, these are the documents.
Hmm.
Just a minute.
Please come to page 69. This is an affidavit of Yogi, that is the petitioner.
69 minutes.
69. Page 2 of the affidavit by
Yes, yes.
Yogi. Please come to paragraph number 6.
Yes, Your Worship. He says names are like that. But they
No,
are,
he says Valian and Kotean belong to my father. Both are my father's name. All along your case is that they are separate. You do not know who is
But
Kotean,
this
but here
affidavit
he
is
is an
that
affidavit.
this affidavit is running contradictory.
I-
Paragraph 4 may be seen.
It is your
I
affidavit.
understand, Your Worship. Some people, they commit mistake.
No, but then this is what has been relied upon. Then how can you find error
Your
with the
Paragraph
impugn?
4 may be. But I
Yes,
say that due to some alphabetical or typographical and or oversight mistakes on part of the officials of revenue authority, name of my father was incorrectly recorded compared as Patel in place of correct alphabetical order of name of LM.
Hmm.
If this is
At
the
the
actual
same
case,
time, no, at the same time, he says they are both
Yes.
same.
so sometimes, Your Worship, people, they write like this, Your Worship, but all along the case is like that. It is basically a mistake.
Then that means a
Again,
false,
Find also typographical error only has been stated.
that means a false statement has been affirmed and a learned advocate was also there.
Your Worship, kindly see paragraph 7 also.
Yes,
That I say that as the best of my knowledge, neither any person in the name of Kotain was ever resided or committed encroachment in the same incident of Bhutan at any point of time, nor the name of Father Andi as indicated with the name of Kotain in the encroachment list belongs to any other encroacher in the vicinity as listed in the encroachment register maintained by the revenue authority Barar branch. So it is not with intention, means I think so, Your Lordship, he might have thought something and I don't know, I can't.
this has been
explain this.
done by a learned advocate, not that the petitioner has done it himself. So a learned advocate has sworn an affidavit which says that these two persons are the same. And then the authority looks into it and says that you cannot show any document. So a further affidavit has to be sworn and said that what is or mentioned in paragraph 6 is incorrect. Isn't it?
And subsequently, Your Lordship, further proceedings were there. Just a minute, Your Lordship, I will just clarify. There was an order. Just a minute. Just 1 minute, Your Lordship, I'm looking that one. Again, the deputy commissioner passed an order, but that order. Maybe one more order is there, I'm not finding it. 20th August 2014, the deputy commissioner passed another order. That order was again challenged before the Honorable High Court. Page number 80 is the order of the Honorable High Court. That order was set aside and it was again remanded to the deputy commissioner for fresh consideration. Then page number 84 is the deputy commissioner's order. Your Worship, what I feel, Your Worship, possibly by saying that Kottayan and Velayan same person, he was often that by mistake the name of Kottayan has been mentioned in the order. And whereas those two persons are one and the same person. It was by mistake the name is written. Some confusion is there, Your Worship, because all along this case is that by mistake. And even the authorities, Your Worship, they also never said that, yes, there was a person named Kottayan at that relevant point of time who was residing in the same land. But the authorities have come to a definite finding that there was a person named Kottayan whose land is situated at a distance from the land of Velayan and his land was regularized. That is the specific case of the authorities. No, Your Worship, here also the deputy commissioner relied. Same order has been passed. What order was passed by the earlier deputy commissioner, same order.
See, time and again, if there is disputed question of facts which is cropping up, now how can the writ court enter into all these things? Because this court cannot adjudicate as to who exactly was in possession. It is a fact-finding thing and it has to be done by the authority themselves.
But the authorities are not doing anything.
They are doing, but not according to your choice.
Not my choice, Your Worship. If they are able to establish, because they have recorded the name, I am in possession of the premises. If they're able to find out, Your Worship, what I am submitting, they found that there is a person named Kottayan. It is not that they did not find it. They found it. But that particular person is a different person. They themselves have recorded.
And then there is recording that Murugappan is your brother, and the previous one you showed that the Murugappan was nobody, just a stand-ins order.
That judgment, Your Worship, of the court, Justice Ariston, Your Worship, it has made it very clear that you cannot mix the case of Murugappan with the petitioner.
No, it is clearly
because in the
recorded.
encroachment register, 378 encroachment register, Murugappan was shown to be the encroacher of that particular land.
Yes.
It is not coming from Velayan. He has separately encroached the land. His land has been separately regularized. I can understand if the Velayan's name is there and thereafter the land has been regularized in the name of Murugappan. Matter would have been different.
Yes, but at the same time, it is found that Sundaram, Yogi, and Murugappan are all sons of late Velayan. All sons of late Velayan were found to be encroachers.
You know,
They are taking into consideration of this.
And type the land, who will get the land, whose name it will be regularized, these are subsequent facts. My contention is that if once the authorities are correcting the name, then the rights of the parties will come. Who will get the land, who will not get the land?
Page number 87, paragraph 16, it mentions the case of Kottayan was considered during the year 2002 and license has been issued in his name. The land is located at a distance from the land
That is what
by the petitioners.
Yes, they found Kottayan is there. Some person Kottayan is there. They found it. And they themselves say that that particular person's land is at a distance from the land of Velayan. But his father's name was Subbalya, not Andi. My father's name is Andi, means Vellayan's father.
Very many dispute. What is the way out? You have already
You know,
filed an
can we
affidavit.
fix it? On Monday, I'm just thinking of something, I'll just speak to my client of that.
What are you thinking?
I'm thinking that I may be given liberty to approve the civil code. I'm thinking of that thing. Because if these disputed questions of fact is there.
Repeated occasions, possibly 3 or 4 occasions, you've shown that the matter was remanded back to the deputy commissioner for reconsideration.
And deputy commissioners repeatedly, they have passed the same order.
Same.
Exactly same order. There is no
Right.
change in the order.
Now, as a writ court, the court has to depend upon the fact finding which has been found out by the authority, because the court cannot find out any factual issue.
If we rely upon the report of the assistant commissioner, one thing is very clear, that Vellayan is there, Kottayan is also there.
Yes.
Now Kottayan land, his father's name is Subbalya. Land of Kottayan has already been regularized, which is at a distance. Under such circumstances, the land which is presently in occupation of the petitioner, the petitioner says that his father's name was wrongly recorded. It is coming from the fact that name of the father is Andi. Son of Andi it is written. And the authorities are not saying that there are many persons or Vellayan had brothers. Kottayan might be the Vellayan's brother. And that is the reason a Kottayan name is written as son of Andi. That is not the case of the authority. That Vellayan had many brothers, might be one of the brothers' name is written in the list maintained by the forest department. That is not the case at all. Under such circumstances, it is to be presumed, Your Lordship.
What will be your submission?
My lord, I stand by the speaking order passed by the Deputy Commissioner.
No, that is all right. You stand by. You cannot go beyond that.
This is
But how do you support it?
my lord, the disputed questions of facts, my lord, the affidavit, supplementary affidavit, they have enclosed in documents the death certificate of one Periyakarpan, not Kottayan. And this, and the Aadhaar card, identity card also.
The petitioner is no way connected with Kottayan. Then
Yes.
how can the petitioner produce documents of Kottayan?
They have affirmed and supplementary affidavit by saying that these affidavits are notarized by children of Kottayan.
Yes.
But the Aadhaar card shows that their father's name is Periyakarpan. They have enclosed not Kottayan. They should have made them a party so that they could have come and upon before this honorable. They have.
Son of Subbalya.
No, you have brought an
Now,
affidavit.
your affidavit supplementary, Kottayan alias Periyakarpan. So again, there is another factual dispute. Very difficult. I don't think the writ court can help you out. You have to go before the suit court to get this done. How many fathers' name alias will come? Have you seen that?
I've seen
The affidavit, page 14.
I've seen that, I've asked my client to search out Kottayan.
Ha.
When he searched out Kottayan, he found one Periyakarpan.
Then you mentioned alias, right?
What to do, Your Lordship?
Yes.
In the death certificate, alias is not there.
And see, in the death certificate of Kottayan, this alias is not there. It can very well be said that you have actually made out this affidavit. There is no genuinity of this affidavit.
This is one affidavit is there, old affidavit of 2002.
But death certificate is subsequent date.
Kindly see. Old affidavit is there. As Shri Kottayan, son of Subbalya, instead of the original name Periyakarpan. One affidavit is there of that particular person. I could get it from the legal heirs of those persons. means Periya Karpan, I got it from.
Then the death certificate doesn't match. Death certificate, it is only
We
mentioned.
tried, Your Lordship. we tried.
You've tried, but then the
Actually,
writ
what
court
happened-
possibly will not
I
be.
understand, Your Lordship. What I did, actually, I wanted to know that in whose name the land has been regularized. That is the main thing. Again and again, the authorities have said that Katayan, son of Subaiya, that land has been regularized. When we searched out, we found that no land has been regularized in the name of Katayan. After much inquiry, we came to know that it is Periya Karpan who was called as Katayan, and in his favor, the land has been regularized. So we contacted the legal heirs of this Katayan. And then we came to know all these, all documents were given by them. This is the situation.
And at the same time, page 69 remains that my father Kotem
Lordship,
is
that
this.
is-
So you cannot
Your Lordship, let me
wriggle
say on
out.
Monday, Your Lordship, I will be seeking that liberty.
Either
Monday.
today or Monday, it is the
No,
same
no, I
thing.
understand, Your Lordship. I'm not going to argue further.
Heard submissions made on behalf of both the parties. Stop. On the prayer of the learned advocate representing the petitioner, comma, list the matter on 31st August.
Here. Obliged.
Obliged, my lord.
Let it appear on top so that it can be disposed of.
But password has become.
All right, yes, call the passover matters. You got relieved from the other bench.
There is one matter, my lord, which is listed. 3 days it was consecutively listed, but as such, I'm sorry, my lord.
All right. Why don't you maintain a team?
But I asked, my lord.
Then
They are
the officers
considering,
are,
it seems they are considering,
what is there?
they're considering.
Considering. Let them consider fast.
I made a request.
You
for-
cannot divide yourself between two. Item 2. Yes.
Yes, sir. Your Lordship, I appear for the petitioner. I serve the private respondent, Your Lordship, but track report I haven't received. So, I'm seeking an interim protection because eviction order has been passed by the.
In the absence of the private respondent, it will be difficult. I make it not today, come back on Monday. As
I'll
it
bring
is
the track report as well.
track report and today there is a resolution.
Like,
All right.
But I'm for the response.
This is a property tax matter, Your Lordship.
Yes.
Resolution. Your Lordship, property tax is regulated by the regulation of Fordland Municipal Council. And also they have the bylaws. Bylaws I have already annexed along with my. This page number 82 is the bylaw.
Who is appearing for the municipal council?
Ma'am,
And you are also there for the lieutenant governor?
Yes, yes.
All the respondents? Are you sure?
But because I filed my reply 2 to 4 only, not.
2 to 4 is all right. What about 1?
But one usually appear, ma'am, because administrator being the head of the authority of municipal council.
Very well. Yes.
Now, Your Lordship, the regulation. Your Lordship, may kindly come to page number 83.
82 bylaws.
Bylaws.
Yes.
Just a minute. Yes. Page number 83. This clause 7.
Yes.
This is the procedure which is given. It says, for the purpose of assessment of property tax, the council shall cause a survey to be conducted by the secretary or the accounts officer or by an officer authorized in this behalf by the council of all the landed properties within the Odler municipal limit during September every year. The survey shall indicate plot number, location, area name of the owner, occupier, nature of the building, whether permanent, semi-permanent, temporary, habitable, etc. Nature of the land in case of vacant land or any other detail which are necessary for the purpose of assessment of property tax. After completion of the survey, the secretary or the account officer, as the case may be.
Lord, one small indulgence. Lord, this matter, when I was practicing, Lord, on behalf of the petitioners, Lordship, I just find it page number 45. I have made a communication to the authorities. Lordship, we kindly see 145.
Yes. SS Hotel Sinclair's Bay.
Because
Is
there's
this the petitioner?
the
Mr.
joint
Sh-
petitioners, Lord, he also a
And
joint
another.
petitioner in that.
So you cannot appear.
That's I'm checking. I just make it not today, my Lord. I make it because Mr. Sivanan will appear because I'm
Yes, somebody else has to
Let
appear.
it not today, my Lord, because this is a old matter.
All right, not
I'm
today.
sorry, my Lord, because I just
It
now
doesn't
checked
matter.
it.
Even I did not notice that.
Let it be wrong, my Lord, because
Yeah.
No, correct.
Lord, here I paid just Tuesday, my Lord, to submit and report. It is with regard to tsunami shelter, my Lord.
Why will cost not be imposed? I have
Lord,
checked
just
the
not today, my
order.
Lord, because Lordship is right. I have received it today, the list, my Lord. I produced it on Monday, my Lord. Let me take it on Tuesday. If I have not done it Tuesday, Lordship will impose costs.
Where is the other side?
But it is from Nicobar districts, my Lord. The old records search out and then brought it, my Lord. That's it.
Whatever.
Just not today, my
All
Lord.
right, not today. There.
I said not today.
You see, it's only not today.
My
The
lord.
cost will be seen on the next day.
Last occasion, it's my lord.
Lord, I
Mark
intimated.
was about to impose
Implicit
costs.
cost.
But
So I
since the
intimated,
practice
my Lord, if
requested,
you are
I
not
did not
submitting,
mark
then
my
the
lord.
consequences which will be followed by the court has to be faced. I'm sorry, Lord.
Item 23.
My lord, I am appearing for the petitioner, my lord. Now, my lord may kindly come to my lord's order at page 84, my lord. I will just place that order and thereafter. Only relevant portion I will place, my lord. My lord has asked me.
Yes.
If my lord comes to page 86, my lord,
Yes.
my lord will find, I am not reading from 85. It says allowances in terms of the office memorandum from the date of their initial engagement till 31st August,
Paragraph.
page 86, my lord, para 3 onwards. Para 3 from page 85.
Yes.
I am reading that page 86 with regard to from which date actually the entire.
Yes. From the date of the
Initial
initial
engagement.
engagement, 31st of August,
Yes.
1993.
Yes, my lord. Thereafter, my lord, may kindly see page 88 of the judgment, para 9. After the disposal of the appeal of the Supreme Court on so and so, the union again filed representation followed by representation. Para 11, my lord. The petitioner contended that no order has been passed by any court of law setting aside modifying the award passed by the Learned Industrial Tribunal, and as such the worker would be entitled to wages on and from the date of their initial engagement. This was our stand, my lord. Now, my lord, may kindly come to page 91. Para 2021. The
93, you said?
91, my lord.
91.
Para
Yes.
20.
Yes.
It says that the prayer of the union was examined by the Lieutenant Governor. An order was passed for payment of daily wages at the rate of so and so with effect from 1st April 2010, subject to the order passed by the Honorable Supreme Court in the pending appeal.
There is no explanation or reason mentioned anywhere in the order of the Lieutenant Governor communicated by the conservator of forest as to why the benefit would be paid to the workers on and from 1st April, even though there is a specific order of the tribunal that the payment is to be made on and from the initial date of engagement of the workers. Thereafter, my lord, para 23. The order of the Lieutenant Governor communicated by the conservator for making payment with effect from appears to be an interim measure taken during the pendency of the appeal before the Supreme Court. The conservator of forest made it explicitly clear that the payment would be made without prejudice to the right and contention of the so and so, so and so. Now, my lord, para 25. The date from which is to be made to a workman cannot be as per the choice of the authority. The subject office memorandum was in work at the time of engagement of the workers, and the same stipulate the payment of the DRM. The authority will be bound by the directive of the office memorandum. Now, my lord, para 27. It is just not understandable as to how the authority choose and fix up a date in random to start making payment. There is no justification at all as to why 1st April 2010 was to be found to be the appropriate auspicious date for which such payment was be made to the workers. All the workers were not engaged on the same day, hence fixing up an arbitrary and imaginary date for making payment to all the workers in one sweep appears to be improper, mechanical and non application of mind. Now, my lord, thereafter, my lord, may kindly come to page 96. Para 39. Though no specific prayer has been made by the petitioner for grant of interest on account of delay in pay, but the court is of the considered opinion that it's a fixed case where the authority should be directed to pay. So, my lord, this was the factual aspect of the case. Now, my lord, when the matter was pending before the Supreme Court, page 64, they accorded regular appointment.
Supreme Court means after this order?
No, not this order. My lord, earlier the award was challenged
Yes.
before the single bench, division bench, thereafter Supreme Court. During the pendency of the award in the Supreme Court, now, my lord, on page 64. On my lord will find
64.
64. This is the
Yes.
regularization order, my lord. 25th May 2015. Subject is ad hoc appointment of DRM eligible in terms of the office memorandum dated 11 December 2006. This memorandum was issued after the judgment of Uma Devi. Now, my lord, it says in pursuance to the Government of India DOPD under reference, the Lieutenant Governor is pleased to approve the appointment of following 122 DRMs who were engaged before 10th April 1996 and had requisite qualification under the pre-revised RR 1992 for the post of Mazdoor at the time of their initial engagement on ad hoc basis in the post of Mazdoor born on the industrial establishment with immediate effect. Now, my lord, this was given immediate effect if my lord comes to page 67 of the said order. Clause 4. It says that the appointment are made subject to final order passed in the special leave petition. So, my lord, it was only a temporary measure to accord regularization on and from 2015. Now, my lord, after the matter was over in the Supreme Court, now, my lord, may kindly come to page 103.
Yes.
It is of 12 July 2021, regularization of ad hoc appointment of DRM in terms of the office memorandum dated 11 December 2006. Consequent upon the dismissal of the SLP by the Supreme Court, while its order dated in pursuance of the office memorandum dated 11 December 2006, Government of India, the Lieutenant Governor is pleased to accord approval appointment of 121 Mazdoor appointed earlier on ad hoc basis in various forest division, while this office letter dated 21st May 2015 on regular basis in the pay band of so and so with effect from 21st May 2015 and also regularize their period spent on order as per the details so and so. Now, my lord, the only issue is, my lord, where from they get this date? Like my lord has recorded in now, my lord, may kindly see the office memorandum, my lord, at page 61 on the basis of which it was done. It says, my lord,
regularization of qualified workers appointed against sanction post in irregular manner. The undersigned is directed to say that the instruction of the engagement of casual labor so and so 7 June 1988 as amplified from time to time inter alia provided that casual workers and persons on daily wages should not be recruited for work of regular nature. They could be engaged only for work of casual or seasonal or intermediate nature of work which is not of full-time nature for which regular posts cannot be created. Attention is also invited to the office memorandum dated 23rd July 2001 wherein it was provided that no appointment shall be made on ad hoc basis by direct recruitment from open market. A constitution bench of Supreme Court in civil appeal number so and so in the case of state of Karnataka versus Uma Devi and others has retrieved that any public appointment has to be in terms of the constitutional scheme. However, the Supreme Court in para 44 of the said judgment dated 10th of April 2006 has directed that the Union of India, the state government and their instrumentalities should take steps to regularize as a one-time measure the service of such irregular appointment who are duly qualified persons in terms of the statutory recruitment rules for the post and who have worked for 10 years or more in duly sanctioned posts but not under the cover of an order of the court or tribunal. The apex court has clarified that if such appointment itself is in infractions of the rules or if it is in violation to the provision of constitution, illegality cannot be regularized. Accordingly, the copy of so and so. So, my lord, the said office memorandum was issued after the judgment of the Supreme Court, whereby directions were issued to the authorities, those who have completed 10 years of service, you regularize their service. So, my lord, 11 December 2006, this was passed. Now, my lord, if my lord sees the language, it is regularized, not to appoint on regular basis. Regularize and appointment on regular basis are entirely two different things, my lord. So, when it comes for regularization, then to my understanding, my lord, I am entitled to get regularization from the date of my initial engagement. So, these are the document, my lord, and this is my prayer which I have made before the this court. And my lord, while passing the award, the labor court has left open to the authority to consider my case for regularization because that award was passed in the year 2005, 13 July 2005. And the Supreme Court judgment came in the month of April 2006. So once that came, they have considered my case by the power which they enjoy and they decided that they will regularize my service. So my lord, it cannot be from a date which is not known to the judge, not in compliance to the judgment of the Supreme Court, my lord. Even for getting this regularization, my lord, I approached this court. That order is also I have enclosed. I am not bothering, my lord. Thereafter, they challenge it before the division bench. Thereafter, before the Supreme Court.
Yes, 21st of May 2015.
Yes, ma'am. My lord, may kindly come to page 49. Lord,
49.
yes, ma'am. That is an award. Page 49. Lord, as Lordship has decided the issue that as an award, it says that the initial date of engagement, they should get 130th. That order has been complied with. The authorities have challenged till Supreme Court. After that, it has been duly completed. They complied it, but they paid with along with the interest. Lord, as Lordship has decided, because the award, it says an initial date of award. Lord, may kindly come to page 47, the award operative part.
Yes.
My lord, may kindly come to this, my lord, Roman 2, my lord. The workmen appearing in serial number 1 to 4 are entitled to the daily wages at 130th pay, minimum and relevant pay scale dealers in terms of the Government of India Office Memorandum dated so and so. Initial engagement till 31/8/1993. So, the award, it says that initial engagement, they are entitled for 130th, which Lordship has decided in the writ petition. My lord, may kindly come to 49. Roman 6, my lord. The matter concerning regulation of the service of the first party workman is left open to decided by the second party with the observation that the second party shall consider the same subject to availability of vacant post in the department and subject to their fulfilling the process of recruitment in accordance with the extent rules, recruitment rules and the general administrative instructions. Lord, this award, they have not challenged. They accepted the position with regard to 6. If your lordship will see, when your lordship is deciding the writ petition, they have not raised this issue well in the writ petition. They only raised with regarding to the date of when it has to be considered for the 130th pay. The lordship has said the 130th pay from the date of initial. Lord, the regulation was left open to the authorities, subject to availability of vacancy. My lord, in my reply, my lord, may kindly come to reply, my lord. Lord, page number 70, my lord. Lord, in the year 2006, and vacancy notice was published.
70, you said?
70, my lord.
70 is the judgment of.
Judgment passed by the our division bench,
Right.
whereby the authorities have kept in abeyance the process of recruitment. But the persons who have been aggrieved, the direct recruitees, went to the tribunal, thereafter come to this honorable court. This honorable court has said, nowhere in the industrial tribunal award, it's mentioned that they have to be regularized. There is no mandatory directions. The post which is already advertised, that has to be filled through the direct recruitment. They are also participated. Some of them have been selected. But the vacancy which has been kept in abeyance for that particular period, in terms of this division bench order, that has filled up.
Filled up from the direct recruits.
All, because the vacancy which is arose at that point of time, it was filled up. Because lordship will see the honorable division bench is specifically mentioned, my lord. My lord, may kindly come to 76.
Yes.
Moreover, the issue of the regulation, my lord, first paragraph, second is lordship 130, the second
Yes,
paragraph.
moreover.
Moreover, the issue of the regulation of 136 daily rated mazurs were left open by the industrial tribunal for consideration of the administration, with the observation that administration should consider the same subject to availability of vacant posts in the department, subject to the fulfillment of process of recruitment rules in accordance with the extent provisions of recruitment rules and the general administrative instructions. The first party 136 daily rated mazurs did not challenge the above merit. So the issue of the regulation reached its finality. The administration initiated a selection process to reference given issuing employment notice on November 2006. The aforesaid daily rated mazur participated in the above selection process. The attention of this course is drawn towards the fact that the names of some of daily rated mazurs appeared in the merit list of the selected candidates. Therefore, the special leave petition under the reference and no nexus with the above issue. So the action on the part of the respondent authority in keeping the selection process under reference in kept in abeyance does not satisfy the test of the reasonableness, and the above action is arbitrary. In view of the above discussions and herein about the decision of Vinod T versus University of Calicut, as no manner application is incident on the basis of distinguishable facts and circumstances of this case, the writ petition is allowed by caution set aside the impugned order dated 10 September 2010 passed in OA 146 AN 2010. We further quash set aside the decision of the respondent authority, keeping the recruitment process and in reference to the captain as reflected in the notice dated 25 by 2000 issued by the respondent number 5. So, Lord, the vacancies has been floated and appointment has been issued based on that vacancy. Lord, Lordship will see, Lordship, they have approached this honorable court. If they have been aggrieved, saying that the part of regulation, it should be a cutoff date has to be from the date of initial engagement, rather the 130th pay which is granted as initial. And that being should be some backup with an order passed by the tribunal. The tribunal categorically has said regulation will be subject to availability of vacancy. Now the division bench has said that is not a mandatory direction. The authorities cannot kept hold for the recruitment process for that particular vacancy cannot be kept hold. You have to complete the regular process. We have completed, we have given an appointment. Now, the ad hoc period is what? Because the Uma Devi judgment, after that Uma Devi, there was an OM circulated by the administration. The first page of the OM has not been enclosed. It was circulated in 2014. The authorities taken backup of that scheme because without any scheme, the regulation cannot be done. It is arbitrary and illegal. 2014, they taken a scheme and given on ad hoc basis. Subsequently, after the Supreme Court's order, they given all the benefit with effect from 2015. And 21,
How could you get this date,
no, that is why I'm
2015?
saying, not this scheme formulated by the administration with regard to the regulation.
Mhm.
Not I, if you lordship want, I can produce that first sheet because the 2000 scheme.
Oh, where is the second page, please show?
Not the second page was enclosed. No, that is a scheme which is 2006. No, 60. Yes, this is the scheme. Not prior to that, it was communicated
Page-
to all. 61, Lord. P5.
61 has been placed.
This is
the
the
scheme.
OM, Lord, which is introduced by the government of India.
Hmm.
Based on this, the that has been forwarded to all the head of the departments.
Hmm.
The administration has taken note of this. They formulated and communication to all of the to implement it, and it reached to the authorities on 2014.
But here also there is no date mentioned, page 61.
Yes, my lord.
The scheme, OM, there is no date mention as to since when the regularization has to be made.
There is no specific date has been given.
Right, so
Subject
how
to
could you
scheme.
get this 2015 date?
Not that's why I'm saying, the first page of this scheme is important, because this is the government of India scheme. It is forwarded to the head of the department over Andaman Nicobar. It was formulated to us, to authorities. If Lordship will just make it not today, I will produce that scheme. I asked this question.
Have you not disclosed in your opposition?
No, this is a scheme, and 2015 is the cutoff date which has been taken into
Where
consideration.
is that cutoff? Where from are you getting that cutoff? This is the question.
Based on the scheme, Lord.
Feelings to that effect. Now my lecturer is
Yes,
making some
you
argument.
are trying to make up something which is not
My lord,
there.
same
No, it is
argument was
there, my
advanced
lord.
in other case before the
Lord,
division
if-
bench, the court did not accept it.
Where is that? There has to be some groundwork
My lord,
for making
my lord,
this argument.
If at all, my lord will take it into that the scheme has not been taken into consideration at this instant. If my lord will say it has to be done in terms of an award.
No, no, no.
Lord, that was their prayer.
All
They
right,
said
all
that was their
right.
prayer.
Assuming from
Yes,
the
ma'am.
date of the award,
Date of
right?
the award.
Now the award mentions that from the date of vacancy.
From the vacancy.
Show the vacancy
So
list.
that's why I'm showing a division bench will not be floated the vacancy in 2006. The vacancy, the division benches, you complete the recruitment process, fill up the vacancy. Lord, that's why I'm pointing out, not division bench. As said, you cannot kept in abeyance the vacancy process in order to consider these persons.
Very well. So the
Vacancies already-
2006 vacancy,
In terms of division bench, it was filled up.
it was filled
Filled
up.
up, but
Then
the-
where did you regularize these people?
That's why, my lord, and ad hoc, they have been regularized. Lord, that is why I'm pointing out. Lord, may kindly come see the ad hoc regulation order, my lord. My lord, may 64, my lord.
Uma Devi came in only to get rid of this ad hoc issue. And then you say that ad hoc
Lord,
regularization.
because my lord, may kindly come once, see, my lord, page number 64 once.
64.
My lord, in pursuance to the government of India's OM reference, Honorable Lieutenant Governor is pleased to approve the appointment of 124 who were engaged on or before 10 and ad hoc qualification of pre-revised qualifications for the Mazur. At the time of the initial ad hoc basis in the post of month on the industrial establishment with immediate effect. No, if Lordship will see the industrial establishment with immediate effect, is allowed those who have requisite minimum qualification 10th pass, though do not have a requisite 10th pass, will be placed on the pay scale of so and so initial, and after completion of the required department training, they will be granted with the benefits from the date of their appointment. Lord, this date when they have been given an ad hoc after the 2021, Lord, may kindly come to the 21 order. My lord, may kindly come to page 103, my lord.
This is challenged. This is exactly under challenge where 21st of
Now
May-
they challenge it, my lord, after the prolonged litigation, now they challenge. My lord, they neither challenge before lordships when 130th was raised. My lord, an award was passed. They are saying an award was passed. Based on an award, you have to regularize me subject to availability of vacancies. Lord, the tribunal has said subject to availability of vacancies. If alone not they have agreed, they could have challenged it at the initial stage. They are not challenged. They only challenge that we should get an initial the 130th from the date of initial engagement in terms of the award.
That has been paid.
Your lordship has said no, you are entitled because the authority cannot do it.
That has been
That
paid.
has been paid.
The money part has been
Money
taken
part has
care
been
of.
paid. They have not challenged the award at any point of time. They have accepted that award. Subsequently, after the 2021, they again come with this, 2015, they issued an ad hoc order. If they were aggrieved, they could have challenged it 2015. Because Lordship's order was the 130th part, Lordship has passed an order. But it starts from page 84.
Yes.
It is, Lordship has passed an order on 3rd December 2020, 10 December 2024. Lord, if they say the ad hoc is arbitrary, illegal, they could have challenged it along with when the writ petition was filed in 2020. They have accepted the position, my lord. They have not raised any issues with regard to that. On 2021, because they given ad hoc, so on 2021, the authorities have regularized the past service with all consequential benefits. If the authorities have said, no, we will give it on 2021, vacancy arose, then the question of you cannot make a person to work for so long period on ad hoc and thereafter you say that no, we will consider it from 21, that is arbitrary, illegal, even I also admit. But here the authorities said, as we have given you on ad hoc on 2015, so the service benefit, everything will be considered retrospectively and all consequence benefits will be paid. The question of challenging the 2021 will come, my lord, when they have to challenge it 2015. Because 15 order, they accepted it. Not a single word have been awarded in the Lordship's order because they only challenge that the award we are entitled for 130th initial payment.
So all along the issue was with
Yes, my
that
lord.
payment.
Payment only. And not with regard to vacancy. Why I am submitting again, Lordship? Because we have, even though we have kept in abeyance the selection process, certain vacancies not be filled up. Because it's all our Mazdoors group D posts. But the division bench has said the tribunal has also affirmed the order passed by the authority, saying that okay. But the division bench said you cannot do it because you are taking under the garb of an award passed by the Labour Code, whereby the Labour Code has categorically held that the vacancies, it is a domain of the administration to consider subject to availability of vacancies. But you, on that basis, you cannot hold a direct recruitment to be hold or kept in abeyance. The division bench said you conclude the selection process. That has been cost. When we have said to kept in abeyance, that cost, the tribunal's order has been cost, we filled up that vacancy. Even some of the persons.
When did you fill it up?
After the division bench order, my lord, which I have enclosed in my lord, it is 2011, the judgment was passed. Page number 17, affidavit of opposition.
2011.
Yes, my lord.
After 2011, you proceeded with filling up
further,
of
my lord, even
vacancies.
certain persons are not qualified also because the 8th pass, but the authorities are relaxed in order to accommodate them. That has been done.
That has been
That
done.
has been done.
And in 2015, it materialized.
Yes. They are given, and after 2021, they have been given all consequences benefit from 2015.
All right, let me hear.
My lord, factually, what my learned friend is submitting is absolutely incorrect. Because, my lord, 2016, if my lord sees page 68, the issue of Supreme Court, because 2015 they have given the ad hoc appointment, and I have shown, my lord, at page 67 that it was subject to outcome of the special leave petition. My lord, special leave petition disposed on 19th of February 2016.
No, but then see page 49,
My lord.
when the tribunal held that,
Yes.
it will be open for the authority to consider the issue of regularization subject to availability of vacant posts.
Absolutely.
You did not challenge.
Absolutely. We have not challenged. We are not on that. This was passed on 13 July 2005.
Right.
Now, my lord, Uma Devi came in 2006.
Right.
Now they consider my case in the light of Uma Devi, not in the light of the award passed by the tribunal. My lord, may kindly see, hell and heaven difference is there. 13 July 2005, the award, the court say you consider their case if vacant posts are available. It was open to them. But that they have never considered. Once Uma Devi came into play, thereafter 11th December 2006, office memorandum came into play. Thereafter, they have considered my case in the light of Uma Devi. My lord will find in both the orders.
that is 2015 order and 21 order. Both the orders, my lord, will find the reference is 11 December 2006. It is not in compliance to the award passed by the Labour Code. Now, my lord, may kindly visualize the situation. Labour Code passed an award in the month of July 2005. Subsequently, they challenge it maybe in the month of September or October. During the period when the writ or writ appeal was pending, Uma Devi judgment came. So there is no requirement to challenge it. Now, my lord, may kindly see 2015 they have passed this order, that page 64, whereby ad hoc appointment was given with the rider that subject to outcome of the special leave petition. Special leave petition disposed in February 2016. Now, my lord, after February 2016, they were pursuing the case for regularization. They have not done. I approached this court. Now, my lord, may kindly see all the three orders of this court. There was no delay, my lord, on our part. Now, my lord, may kindly come to the order of the writ court. My lord, may kindly come to page 98. We filed a writ petition. We have approaching the authorities for 2-3 years for regularization. They have not done. We approached this court. Now, my lord, 2019. Yes,
That sounds.
now, my lord, may kindly see December 18, 2019. The court says the grievances of the present petitioner is that the members of the petitioner number 1 was daily rated Mazdoor under. Subsequently, there were several litigation in the matter and ultimately it was upheld. 130th was given. However, the respondent authorities took up the matter to the Supreme Court, and during the pendency of the SLP, such payments started being disbursed to the members of the petitioner number 1. Thereafter, the petitioner number 1 were even given regularization in terms of Uma Devi, but on ad hoc basis. Ultimately, by a communication dated 8 July by the office of the so-and-so, the respondent number 4, it was categorically indicate that the department has finalized the appointment of 122 DRM on ad hoc basis and subsequently to the case of Uma Devi and pursuant thereof. And in view of the special leave petition filed by the respondent authority have been disposed of by the Supreme Court, the department has already initiated the process of appointment as regular Mazdoor. It may also be recorded that subsequent to Uma Devi judgment, there was a government notification as well as consequence thereof, which was given effect to by a communication dated so-and-so. However, subsequently it was found from a communication that the authorities are dilly-dallying with the matter and have solicited approval of the competent authority for regularization of the DRM. The grievances of the members of the petition number 1 is that subsequent to the communication dated 8 July 2018, which is annexed to the writ petition as annexure so-and-so, there is no scope for further delay. The matter and process of appointment, including the members of the petitioner as regular Mazdoor, should be considered reasonable soon. Learned Senior Counsel appearing for the administration under instruction submitted that the said regularization process will be expedited and shall be completed within a period of 3 months from this date. In any event, the respondent also cannot resile from their position as stated in the communication. Accordingly, so-and-so is disposed of, directing to complete the process of regularization who are represented. Now, my lord will find there is an undertaking given by the senior advocate saying that within 3 months we will do that on instruction. Now, my lord, they have carried it on in appeal. Page 100. My lord, may kindly see. If my lord sees 101, it says, it starts from 100, my lord, 101.
Yes.
The appeal is arising out of an order dated 18 December 2019 in relation to the regularization of 120 DRM. The learned single judge, after taking into consideration the judgment in Uma Devi and the subsequent notification of the administration, directed the administration should not make any further delay in process so-and-so. The learned single judge also recorded so-and-so, so-and-so. My lord, under such circumstances, straight away, my lord, the court says we do not find any reason to interfere. Despite of giving an undertaking, they filed it appeal. Now, my lord, may kindly see, they did not stop here. They went to Supreme Court. They filed an SLP. SLP was dismissed on 9 March 2021. Now, my lord, after the dismissal of this SLP, that order was passed on 12th of July 2021. Now, my lord, at no point of time we were any delay was on our part, and my lord will find in all occasions the consideration was on the basis of the judgment of Uma Devi, not on the basis of the award passed by the Labour Court. Now, my lord, when this order was passed on 12 July 2015, they regularized it from 2015. What is auspicious in that day, my lord? Why they have regularized it from 2015? That ought to be from the date of initial engagement. If we go by the definition of regularization as narrated in the definition of the office memorandum dated 11 December 2006, or at least from 2006, under no stretch of imagination.
My lord, once the government, my lord, once a judiciary has passed an order, on the basis of that, Government of India has issued an order. Thereafter, where the administration stand to issue any further notification, they will take 12 years and they will say that we will subsequently regularize them from a subsequent date, whether it can be done. And my lord, the judgment which my learned friend refer, that has got nothing to do with this case. Nothing to do with this case.
Kindly come to their prayer.
Wait, 1 minute, not all at the same time.
I'm sorry.
Yes.
So, my lord, it is, and my lord has considered, with regard to delay, they have argued before my lord also. My lord, may kindly see para 32 of my lord's judgment. Same argument was advanced. My lord, may kindly come to page 94, inner page 11. The issue of limitation raised by the respondent also cannot be accepted by this court. It appears that the workmen pursued their claim in a steady manner since 2002, when the order was passed by the Lieutenant Governor in the issue was pending adjudication before the Supreme Court. After disposal of the appeal before the Supreme Court, the worker immediately took up. So, my lord has also considered that it was pending before the Supreme Court. Thereafter, we were pursuing before the court. You were approaching, my lord, for giving the benefit which you are entitled under a judgment of the Supreme Court. You are running, my lord, from up to Supreme Court. And because of that, it was delayed. My lord, after 2015, February 2016, Supreme Court disposed the SLP, my lord. Their SLP. Thereafter, it took at least, my lord, 7 years for them to accord this benefit in the year 2021, my lord, after 16. And despite of an order passed by this court, where is it the delay, my lord, on our part?
Lord, may kindly just see that prayer also. Page number 31. The writ petition.
Prayer in the writ petition?
Yes, my lord.
What is the prayer?
No, they not challenge the 15. In this instant writ petition also, they have accepted the position of 2015 ad hoc appointment. My lord, we see, they kindly read it, but they want the benefit should be done in terms of an award. Considering the award dated 13/7/2005 and the judgment of Supreme Court. There cannot, they himself is saying award, then Supreme Court.
That may be my mistake.
Lord, that is cannot be his mistake, Lord, because they accepted the position of the award.
All right, hearing concluded, CAV.
Oblige.
Is there any other Passover matter? No. Then let it remain till here.
But this item number 29, my lord,
Yes.
it's a short matter. Next tomorrow, if it is upgraded, both are agreeable to that.
This, my lord,
29,
one said, we say that is the proposition we have to follow.
29, 30, 31 together.
Yes, together.
No, I can take it up now also if you all agree.
Yes, my lord, it's a short matter.
Yes, then give 29. Please give.
My lord, the issue is, my lord,
Hmm.
compassionate appointment was initially governed by 1958 office memorandum. Subsequently, several notifications were come. All along, the criteria was first seniority, my lord. Seniority. On the basis of seniority, who died earlier, his incumbent will get the job. That was the law, my lord, up to 1st of August 2022. 2nd August 2022, a compendium of all the notifications were taken into account, and the government has decided now seniority would not be the governing factor. The governing factor would be the social status of the individual.
Financial
Financial status, how they will be, how they will their status in the society, whether they are really in need of compassionate appointment or not, that would be the criteria. Now, my lord, before issuance of that, the government of India has issued a circular whereby the government of India says that you have to adopt a modality, that what would be the criteria, how you will assess the criteria. For that, you have to adopt a modality. Here in this case, my lord, they have not at all adopted a modality. My only prayer is that, and on the basis of pick and choose, my lord, they want to give the benefit to some of the incumbents. When we filed this writ petition, they stalled it, they have stopped it. Now, my lord, my only prayer would be, my lord, let them form a modality, my lord, on the basis of which, because the modality is the requirement in terms of the scheme. My lord, may kindly come to, my lord, the scheme. First application, my lord, may kindly come to the compassionate appointment scheme, clause 13. My lord, that I have reproduced in my writ petition itself. My lord, may kindly have my writ petition, my lord, at page number 12.
Clause 13, page 63, it is there.
Yes, my lord. 63.
Hmm.
Now, my lord will find, my lord may straight away come to clause 6.
Yes.
It says that some departments such as CBIC, Director of Postal, Director of Defense has devised their own point-based merit system for processing claim for compassionate appointment. In order to bring in transparency and objective in dealing with such claim, all ministry department who have not yet developed such a system may do so by devising their own point-based merit system for assessing the merit of the claim of compassionate appointment. My only grievances is that you have to do this. My lord, a model office memorandum was issued by the government of India, how the modality has to be accepted. On the basis of this, my lord, they have to do it. But what they are doing, my lord, every area, geographical structure, everything has to be considered. They adopting this one straight away, this model office memorandum, which is there, on the basis of there, they are assessing, instead of having their own modality. This is the only grievances. If my lord sees this, if my lord sees page number 4 of this OM, which I have handed over, my lord.
Yes.
My lord, this is the criteria which has been given, but they have to adopt their own for having transparency. My lord, the cases may be, my lord, here there may be cases, there were several persons for compassionate appointment. Then they have to adopt their own criteria, how they will accommodate, whether their the posts are more or the posts are less, because only 5% they will get, my lord, under this scheme. So therefore, they have to adopt the very purpose, my lord. If they are going by the office memorandum, they cannot pick and choose some of the clause and they do it. Clause 13, subclause 6 is very clear. You adopt it and do it in accordance with law.
Right now, what is the scheme that they are following?
They are following this
method. We
This
followed
one?
the same method and we have been done.
This one?
Yes.
My lord, this is the modality.
17th June
Yes.
2022, you are following?
Yes, my lord.
No, this is the modality, my lord.
The
Up-
government has. Absolutely.
Yes.
My lord, the scheme is of 2nd August 2022.
Right.
Scheme clause 13, subclause 6 says.
So your submission is that clause 13(6) and the office memorandum, they are not at par with.
No, my lord. Clause 6 says they have to adopt their own point base. My lord,
Suppose they accept this and say this is my point base. How can you say it cannot be?
my lord, first of all, they have not accepted it.
No,
No,
we
So
have
he
done
says
one
he
case.
No,
accepted.
We have enclosed the details.
Something, my learned friends, my lord, what I am on,
Huh?
if they have accepted, they have to because it's an autonomous body, they have to accept, they have to have the minutes of meeting and all.
No, that is.
What I am saying, my lord, this acceptance ought to be on the basis of geographical structure of the area where they are going to be governed. Our island is an isolated island. Now, my lord, we have to see how many workers are there, 5% ratio, what would be, and what would be the criteria, because seniority has gone. Now the seniority issue has gone. So, my lord, what prevented them to adopt their own device, own point-wise? Because, my lord, clause 6 never says, my lord, they can accept it. I am not saying that they cannot, but I say, my lord, to have a transparency, they could have devised their own point-based method, and that would be brought in public domain so that we can know what was the procedure which has been adopted by them.
Have you floated any scheme?
My lord,
No.
my lord, may kindly come to the scheme, page number 30 of the affidavit in opposition. My lord, under
Affidavit in
clause.
opposition, please give. Page number 30. Where is the scheme? Page 30 of the opposition. Have you annexed the scheme?
Yes, my lord, I have enclosed the scheme.
Yes, 30.
Lord is looking for item 221.
M. Lakshman,
Yes.
221.
My lord, may kindly come to page number.
You
Note
annexed
13
the
is the
second-
procedure. My lord, may kindly come to page number 26, my lord, 26.
Place, my lord.
That is,
It is the same
we
thing.
also follow the same thing. My lord, may kindly come to page number 26.
Page number 26.
Roman 11, my lord. 26,
Roman
Roman 11. Every valid application shall be assessed strictly on the basis of the point-based merit system formulated by the concerned administrative ministry department.
Show your
Not the
point-based
subsequent
merit
point-based
system.
my brother has pointed out just now.
No, this is of home ministry.
This is of the Home Ministry.
Not they have
Where
followed
is your-
that.
Show me your resolution that you
My lord, may
accepted.
kindly
it.
come to the reply, the tabulation sheet, page number 39.
Reply.
No, this is an affidavit opposition. Same.
Which
39,
page?
39.
Page 39. Yes.
Based on
it's on-
this annexure 1, the entire tabulation has been prepared, my lord.
You just show where is your scheme.
Lord, we are not required to formulate a scheme, my lord, because their scheme
Very
was
well,
formulated by
very
Government of
well.
India.
Assuming that you are not required to formulate a separate scheme,
Yes, my lord.
there must be some resolution on your from your department accepting the scheme of the OM. Where is that?
Lord, that is the because, my lord, the scheme says you have to adopt the point-based.
You all have adopted. Show me that you all have adopted the adoption
Lord,
of
then
this
also-
scheme.
If lordship will say, then also, my lord, on the merit, they are not coming. They are.
That is a different thing. Whether they come on merits is different.
Lord,
But
we-
the scheme, what exactly is the
Lordship wants to
scheme?
know whether we have adopted this.
Adopted, yes.
So I will produce the minute.
Clause 6, my lord.
In the selection process, the minutes it will be there.
By device.
Something must
Something
have
must
been
be-
there
minutes.
that as
Based
per
on the-
the scheme or something.
Obviously, my lord, because
By device.
the assessment was done based on the point-based system only. If lordship will see name of the person, relationship, education qualification, wife applied for compensation, the point-based system, Lord, it has been given. The family pension, who are getting more, they will get a point. Lordship, because so that the person who is really required to be harness of livelihood, they will get the job.
Financial stringency
Absolutely
is the first.
Earlier, there was an seniority basis was there because based on seniority, it was to be done.
And my lord,
After
my
2022, it was changed that you have to do it on the basis of point-based system. These applications, the process, everything was done based on the office number 2022 and the point-based system only. If lordship will see the tabulation sheet, the points have been given. And overall total, my lord, last column. So the petitioner is neither.
Maybe that is different. One petitioner will not get, somebody else will get.
Whoever
Whoever is
merit
the
will, they will get. There are two posts.
Yes, whoever is the best suitable candidate,
They will get.
candidate will get. Now, the question
page
is
26, my
whether
lord. My prayer.
the challenge is to the scheme. Now, if there is no scheme, then what
Page
can be done?
26 only, my lord. My
My lord,
prayer,
there is
what
no
I have
scheme. The
argued,
lordship
that
will
is my
kindly
prayer.
come to the minutes of proceedings, my lord, page number 35, I enclosed.
26.
35 of the minutes of proceedings.
To promulgate promulgate, devise a scheme in terms of clause 3 and to consider the case of the petitioner.
Same what I have
Lord,
argued
we are
before,
not
my
doing
lord.
It's all right, but then you cannot stop them from adopting this scheme.
Lord,
But
the
they have
division
not
bench has
adopted, my
said,
lord.
Lord,
Let them
the
show
division
that they have
bench in
adopted.
Central administrative term, but brother has appeared. The same issues was covered up in division bench has said, if they are adopting the scheme of the government of India, they can very well do
They
so.
can do so. True,
That is
but
what the
show that it
I think
has.
my brother will not deny.
I
No,
don't
no, show me. Please show me that you have adopted.
My lord, that is if lordship will see page number 35, the minutes of proceedings.
35 of your opposition?
Yes, my lord. Third paragraph, my lord, from the
Third
bottom,
paragraph.
first, last paragraph from the bottom.
Uh-huh.
The committee noted the eligibility criteria issued by the DOPT, which is as follows. The committee, my lord, and they have taken into consideration. The committee noted the 5%. The OM was, my lord, that is with regard to 2nd August 2022.
There is no whisper of that OM 70.
Lord, it is that 2nd August 2022 is the OM.
In June is required.
2nd June is the This is the mark system, my lord. The scheme is that 2022. It was given in 17 June is only the point-based system. If your lordship will see the OM, I pointed out not Roman 11. It says every authorities has to adopt the point-based system formulated by the ministry and the department. So this is formulated by the ministry. The OM we have adopted.
That OM says, my lord, under section.
Lord,
that is
my
surplus.
lord, there is an arbitrary illegality.
Maybe assuming there is no formal adoption, but if they follow, you cannot stop them.
No, my lord, they are
Lord,
following.
if there is an arbitrariness,
Second
illegality,
That
then
is
because
different.
that is a
That is
different.
My lord, they are following 2nd August 2022. They have said, my lord, 2nd August 2022, clause 13, Roman 6 warrant that they must have their own device method, my lord.
Their device method is the
But
next modality that has come.
But that is not there in the proceeding, which my learned friend says. 17 June is not at all there.
17th June
Let him
2022.
show from the proceeding. There is a whisper of 17 June.
Here it is there, 35, 17 June 2022. It has been taken into consideration. See,
35.
page 35, Annexure D, 2nd August, 17 June 2022 also. Committee perused the various office memorandums. See,
17 June 2022.
penultimate and the last date is 17 June 2022. So they have followed it.
My lord.
You cannot, now if there is any legality, then that is separate. But you have to take it that they are doing it by adopting. So nothing remains. If you have a challenge, you can always challenge it. Please come.
Then in that case, my lord, I will not pursue with it. And when an occasion on merit, I will argue.
Absolutely.
Yes, because here I have not argued on merit.
This writ petition goes.
Yes.
If you have a case that there has been discrimination, there is a lack of transparency, legality, contrary to the June memorandum, then it is all right.
If the wrongly person has given points have been mismatched or they are not entered for that point.
That is a
that
different
can be
thing on
different
merits.
percentage.
That is
On merit,
different.
I have said nothing, my lord.
Yes, 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 followed. The matter relates to adoption of the scheme for compassionate appointment to be followed by the respondents at the time of consideration of the prayer made for compassionate appointment. Step. Specific stand of the paragraph. The petitioner has prayed for a direction upon the respondent authorities to promulgate and devise a scheme in terms of clause 13 within bracket VI 6, Roman 6 of the office memorandum dated 2nd August 2022. Stop. The it appears from the submission made on behalf of the respondents and on perusal of the affidavit in opposition filed by the respondents that the authority is following the scheme of compassionate appointment strictly in accordance with the office memorandum dated 17th June 2022, followed by office memorandum dated 2nd August 2022. Stop paragraph.
Then my lord may record it, my lord. Nothing survives then.
Yes. As the authority is acting in terms of the scheme published by the Ministry of Home Affairs, Government of India, accordingly nothing survives to be decided in the instant writ petition. Stop. The writ petition stands disposed of. Stop. As and when individual grievance of the petitioner arises, it will be open for the petitioner to agitate the same before the competent forum in accordance with law, if so advised.
Highly obliged. All three, my lord, are same.
All three can be disposed of, 29, 30 and 31. All right.
Yes.
Article 300, sir.